Stop all the question marks.
Alright, Jerry, we good?
Check, check. Mine isn't working, but it's okay.
You want to use this?
No, we get a small one. I don't think it's an issue. That was the other thing. My mic didn't work at the beginning. We can't hear you.
Well, they said that to everybody. You had to have your mouth right.
You basically had to
Poor
be a
Eleanor, who
performer.
had to read
How do you
this.
think that was the ideal
Yeah.
distance without the reading glasses? Is completely conflicting with the ideal.
That was mean that I made you read those.
I
without
know,
your
and they were
reading
really long.
So painful, so painful.
I felt really bad for her.
I did too. I would like to thank Eleanor.
Yes, thank you, Eleanor.
Struggling through those.
Ugh.
All right, let's
Okay.
get going. This is the regularly scheduled Town of Nantucket Board of Appeals meeting for September 6, 2018. Can I get an approval of the minutes of August 9th, 2018? Michael makes the motion. Anybody want to second that?
I'll second.
Jeffrey seconds. Any further discussion? No? All in favor, say aye. Aye.
Michael, you want to hand me that other decision?
That was unanimous.
Mr. Gentle, if I may, just to let you know that the website, as you may have noticed, has been revamped. I am fully aware that there are things on the ZBA website that they're called assets, that weren't properly transferred over. So I notified them right away, and they're slowly but surely, I have 3 websites I'm in charge of, that's the first one I attacked. So if you're seeing something
Jeff.
that is, if you're not seeing something you think should be there, and I've been notified by people, let me know. I may have missed it, because there's
Okay.
a lot that had to be transferred.
Okay, thank you. Right, so on to, well, can I get an approval of the agenda as written? Wasn't
So
amended,
moved.
right? Okay. You second that, Michael? Michael seconds it. Any further discussion? No. All those in favor say aye. Aye. Okay, so moving on. Old business, 1918 Act Crazy LLC, 9 Westchester Street, for the applicant. Is anybody here for that today?
As you know, I represent the butters.
Right.
The,
We just said, I know who you are, obviously. Will you identify yourself for the tape?
Arthur Reed. The applicant's representative was here just a minute ago. We have been working on an agreement to enable them to come on our property in connection with work. Something's been drafted. I thought we had an agreement on it, but I just heard a few minutes before the meeting that they want to have their attorney, who is Cohen, take a look at it and continue the matter until the October meeting. And that's their request, but we certainly are agreeable to
Okay.
that.
So, just out of curiosity, when is the
October 11th.
October 11th? Okay. So.
Do we need an extension then?
I believe that it's good till October 12th. If I did get an extension last time, it should be.
Yeah, it's good to midnight on October 11th.
Did you say 11th on the?
Yeah.
I mean, I think we should do it anyway, because even if there's a vote on that meeting.
Yeah.
We'll run out.
Yeah.
Okay. So, but, yeah, are you gonna sign on their behalf,
Yes, I will.
Steve?
Yeah, I have not participated in this yet, but I've been retained now to do so, yeah.
The next meeting is the 11th.
So maybe we should do it in November.
Yeah.
Thank you.
All right. So, will someone make a motion to, do we have to do the extension first? Do we have to, how do
You
we do?
should approve the extension and then.
Yeah. Make a motion to approve the extension till, what was the date?
October 11th.
October 11th.
No,
No, the
that,
extension.
that's the
I'm sorry,
extension.
that will be, 1 second, it will be November 9th.
November 9th,
I'll make that motion.
2019, okay. Lisa makes a motion. Who wants to second that? Jim seconds it, okay. Any further discussion? No. All those in favor say aye.
Aye.
All right, so then how about a motion to continue to October 11th?
I'll make that motion.
Jim? All right, so motion's been made and seconded. Any further discussion? No. All those in favor say aye. Aye. Okay, thank you.
Thank you.
One down.
So should we go to new business because John Brescher's not here? Or Jesse?
I guess so. So we're gonna pass over 2918 for now and go
No,
to,
you have to,
oh, we have to continue? We have to vote on the continuance
Oh,
of Adam Ross?
correct.
Okay, so 2318, Adam Ross and Emma Ross, 50 Okarawa Avenue. They'd like to continue to October 11th, 2018. All right, Michael makes the motion. Who seconds it?
I'll second. Oh,
Jeff seconded it. Any further discussion?
Nope.
No. All those in favor say aye.
Aye.
Okay. So we'll just postpone, hopefully within this meeting, 2918, and go right to 3118, new business. Richard Boileau and Patricia Boileau.
Bollier.
Yeah.
Pine Grove Act LLC, 18 Pine Grove Lane, for the applicant.
Sure. Stephen Cohen for the applicant. My client is the contract purchaser of this property, and the house sits at the street level, and then the yard slopes off fairly significantly behind it. I don't know if you're familiar with the area, but it's all wetlands, and there's a very narrow area where an addition could be built. It goes not quite setback to setback, but there's parking on either side, and there's the setback at the front. So the only place on the lot that you could do an addition is in the back, and it can only be 8 feet deep. I think your packet actually says 8 feet tall and 12 feet deep, which is backwards. It's really supposed to be 8 feet deep and 12 feet tall. So the house currently has a walkout basement. In other words, you enter on the first floor, but the backyard the basement is at grade for the walkout part. So what my client has done is obtain a permit from the planning board to turn the basement into a legal tertiary dwelling, and one of the things that they want to do is add some higher ceiling livable space. So they want to do an 8-foot deep, 12-foot tall addition to the basement, which would be at grade at that side. The anomaly is that because of the way the bylaw works, because you measure from 4 feet from the foundation, by going down the hill, it actually makes the height of the current building mathematically taller, even though the building itself is not getting any taller, even though the actual addition is practically below grade from the street. The building itself mathematically is getting taller at its height calculation, not in reality. The building itself is actually over ground cover, over the height calculation. If you look at the calculations that we did, one of the sides is above the maximum 32 feet. It's 32 and a half feet. That is considered pre-existing non-conforming at this point, and it's not something that was really monitored at the time this house was built, although the bylaw was in place. The request is to essentially build this addition that would have one side of the building be 34.4 feet tall, and the height of the building would be 30 feet tall. So it's compliant as to total calculated height, but not compliant on the single side measurement. Does that make sense? Mm-hmm. And then there's a letter from our surveyor engineer, Arcasparo, that says that as well. So that's the request, to do the single story 8 foot by however wide the building is, approximately 12-foot tall addition, but to have that impact the height calculation. So it could be,
City approval here is,
yeah, it's HDC approved and planning board approved
and they're allowed to have those 2 curb cuts?
under the planning board permit, yes.
Do we have the planning board?
Well, we have a as-built from Art on page 144.
The current
That shows that.
That
house
shows,
The signatures.
is
oh, not the planning board signatures, no.
the current house is illegally used as a multifamily unit and has parking end to end. So my client is actually reducing both the occupancy load and the amount of the yard that's driveway, and legalizing everything and putting in sprinklers. And this is, I think, a benefit to see it go from an illegally overburdened lot to a legally permitted lot. And it is a year-round restriction on the tertiary dwelling.
Okay. Was this the one that was, I thought that, so the tertiary dwelling is restricted to year-round. I thought one of the ones we read about was second floor unit was restricted.
So the basement is one of the larger units. It's the basement where the addition is not the tertiary dwelling. The tertiary, I think, is the third floor unit or the second
It
floor
has to
unit.
be below a certain amount of square footage.
Yeah,
Well, it says convert the first floor mid-level
yeah.
to a 798 square foot, 2-bedroom tertiary dwelling. Okay, so the mid,
Unit 2.
Yeah,
that
that's
will
been
be,
approved by the planning board already.
okay, and that
We do
is,
have a special permit for the excess in size.
We do, yeah.
Yeah.
And again, it's because it's an existing dwelling and that calculation actually includes a staircase. So if you look at just the livable space, it's smaller. But the planning board's already addressed that. This is strictly about the height.
all right, how's everyone feel about this?
No issue.
You could do it as a special permit or a variance. We've applied for both.
Yeah, I would prefer the special permit. So, how does everyone feel about that?
I agree.
Are everyone okay with it?
The maximum height per side is 34 normally, right?
I'm sorry, what?
32.
32 maximum
32. Yeah.
per height?
Yeah, it's 30 feet total and no side taller than 32. And here we have 30
34.
total, but one side that's 34.4
Right.
on one side. So because one side is 32.5 already, and that's grandfathered by being more than 10 years old, we could piggyback that nonconformity to do a special permit.
Yeah. That makes sense. I'd rather do that than a variance.
Okay. So, having said that, does somebody want to make a motion to grant the relief pursuant to zoning bylaw section 139-33A and 139-17?
Does anyone in the audience have?
Does anybody in the audience want to talk about this one? Our audience numbers have dropped markedly.
Very impressive numbers, Mr. Chairman. Not quite inauguration size, but very impressive numbers.
No, that was
Well,
the
you have to
largest
talk to Sean Spicer
ZBA.
about
I
that.
can say that was the largest ZBA crowd ever.
For sure it was.
Without even Photoshop, right?
Without Photoshop.
It might have been the longest, too.
I heard the
I don't
sales-
think it was the longest.
The sale of sleeping medication was way down after that.
Right.
No, it's down.
Anyway, let's get on track here. So, want to grant the relief as requested with a
Yes.
special permit?
I'll make that motion.
So Lisa makes the motion. Want to second it, Jeff? All right, so probably the 5 regular members would vote on this. All those in favor say aye. Aye.
Aye.
All those opposed? 0. Okay, thank you. Okay.
Wrapping up then?
Okay.
3218.
Jesse's here. Oh,
Oh,
Do you want to
yeah,
go back to Jesse?
we can do that.
Thanks, sir. Yeah, that's fine.
Okay, so I'm not sitting on that one. So Susan, you're up.
this is, there we go.
Okay, so this is 2918 Gordon E.W. Gilbertson and Nancy Ann Gilbertson and 34 Dukes Road LLC.
Good afternoon. Jessie Brescia for the applicant. As you may recall, we talked about this last month. I believe the board had asked me to get an affidavit from Mr. Gilbertson, which I have done and is included in your packet, which basically outlines what brings us here to this issue. simplest version is that there was litigation in Florida, and as a result of that litigation, the order from that court directed that Mr. Gilbertson, Gordon Gilbertson, who at that time owned 32 Dukes Road in his own name, be given the lot at 34 Dukes Road. And it's that order that merged these properties. We've done everything we can on our end to sort of undo what that Florida court order did. We had the court order amended in Florida. It's been filed here at the Nantucket Probate Court. The license to transfer the property under the Nantucket ancillary probate has also been amended, and a confirmatory deed based on the amended license has been recorded at the Registry of Deeds. So we've done everything we could do to possibly sort of undo the damage from the Florida court, but because it just looks bad, for lack of a better phrase, the property is under agreement. The buyer's attorney has asked that we come to get, I believe at this point it should be a variance, but I would leave it obviously to the board to determine. I believe town council issued an opinion as well that suggested that if there's any common ownership at any time, no matter how short that ownership is, the properties merge. And also I think the planning board suggested that if this board saw fit to grant relief, that a variance was the appropriate method by which relief would be granted. I have copies here. I've got 5 copies. I submitted a full copy of the original court order, and I've highlighted the language here. And then I also have a copy of the amended court order. Just says that it's the title in 34 is to be transferred to the 34 Dukes Road LLC as opposed to Gordon individually. So I'm happy to share these with you, every board member, if you'd like them. But they are submitted with Eleanor, so she can include them in the file as well. And I'm happy to answer any other questions or if there's any other issues. Oh, the other thing, I submitted all the copies of the tax assessor's records going back to, I think 88 was the first book I was able to find without pulling out the microfiche. So I started with 88 and basically did every 5 years thereafter to show that according to the assessors and at the Registry of Deeds, Charlotte Gilbertson was listed as the owner of 34 Dukes Road, while her brother Gordon was listed as the owner of 32 Dukes Road. And again, that didn't change until after Charlotte died in 2014. I think fiscal year, I think it's 2016 was the first year in which that change is noted in the assessor's records, and that's as a result of stuff that we were doing to carry out the Florida court order. And then this was later brought to our attention that this is now a merger issue. We then immediately undertook to do whatever we could do to sort of backtrack out of that. Sorry.
I'm just reading the town council.
Do you have a question? I think that calls the question.
Oh, go ahead.
Sorry, go ahead.
Nothing. I thought you were asking me to speak, but what was your question?
We asked that town council give us their opinion.
Yeah, this is a
Did
letter.
that happen?
Yeah, that's a letter. She's reading that right now.
Yeah. But it's interesting because he says, from his review, he says it's unclear whether title to both lots was ever held in the same named individuals. But applicant's counsel appears to acknowledge that merger of title did occur as a result of the settlement and probate litigation in the state of Florida. And that if the title was ever held by the same individuals, then the lots would have merged, and that our bylaw is a little looser than state law in Massachusetts. But I'm wondering if we can. Yeah, sorry.
I have a copy of the order that we're referring to, which I don't believe town council had at that time, and I'm happy to provide that to each of you.
The one from Florida?
So the top copy, and I've highlighted the language, is the order initially. It's saying who owns what and where they're supposed to go, and the second page is the amended order that we just recently received. That's the amended change.
I think you should sit on it because for some reason we have him having a conflict in the last meeting.
So the opinion of the town council is it merged?
Well, he was saying under the, I'm reading it that what he researched, he didn't see that it merged, like based on Massachusetts, examining Massachusetts title standards, he didn't find anything to show that it merged.
It's unintentional. That's what he's
Right, but
But he's saying if it is unintentional or of short duration would not, in my opinion, alter the fact that the lots had merged.
But
So
they
instead of
merged,
saying-
right, but I'm just thinking like they merged because of a decision in Florida, not, if it had been done in Massachusetts, would it have been done differently to avoid merger? Probably.
By point of clarification too, a copy of the Florida order is on file at the Massachusetts, the Nantucket Probate Court, which makes it part of the public record here in Massachusetts and part of the record title to the property, which is what got us here. I think possibly if it had just been done in Florida
Right,
and nothing had ever been filed in Nantucket County, either in the registry or in the probate, there may have been a way to sort of back end around this because it wouldn't not have, no one in Nantucket would have had any idea that this thing in Florida even existed. But because it was filed at the Nantucket Probate Court incorporates all of the Florida actions sort of into the Mass and specifically Nantucket record title for these properties.
So then what we're being asked, I mean, I think town council didn't really address the question that we had, was more if it's amended and then goes back and changes it, does that satisfy on,
I mean,
getting rid of the merger?
He's saying it's merged, is that right?
That's my opinion of his take as well.
Recognize Florida law, whatever happens.
Right, right.
So it's done in Massachusetts.
Yeah, I thought the question that we had for town council, right, I thought the town council we were asking from my notes was to confirm that if it was if this order was amended to send it to an LLC, that would be retroactively like
Well,
okay.
My concern on that is, I know based on these facts, it would make sense, but can then, are we setting precedents? Can anybody do this now?
Right.
Drop it into an LLC and say,
Right.
oh, it's temporary,
Right. I mean, I'm
realizing
I-
it. And that's my biggest concern is
I'm not
setting precedent here if we allow this scenario to happen, it merged,
yeah.
and now we want to unwind it.
Yeah.
Correct the deed or drop it into an LLC.
Yeah.
And
Yeah, I think we
do
were
that.
I think we were all in agreement that it had merged. I think I thought we were asking town council whether or not this
He had all the documentation up to, this was submitted late Monday night, so he did not have that, or Tuesday. So he did not have the most recent amended order, but he had
Yeah.
everything else.
I
So he would have based his assertion and his opinion on all the documentation that I sent him, which
Mhm.
included everything up to this.
Does it make sense to continue this for another relook from town council at this additional documentation?
right, because I don't think I don't want to make policy on how exactly what Jim said. If you can go back and edit it and drop it into an LLC, now the merger is undone.
May I suggest too, I mean, I think that the variance approach doesn't set the precedent. I think that's, I mean, a variance is very specific to the circumstances as opposed to a finding that no relief is necessary. I think a finding that no relief is necessary could potentially open the door for people to do this, but I think a variance is limited to the very specific circumstances of this scenario that are hopefully unlikely to ever happen again. Certainly, hopefully they never cross my desk.
Right, but I think the issue is that town council has said that it did merge, even if it was unintentional, or even if it was just for a few days or a few years or whatever. And I don't think we can just undo.
I think by variance, you can, it's been done in the past, I believe there've been unintentional mergers where husband and wife owned a property and one passed away, and there was an unintentional merger, and I believe this board has issued a variance in those circumstances to basically unmerge them where the merger was completely unintentional and was not a sort of a control issue.
Did we do that on North Liberty Street where Val Maitino's shop used to be? Is that a variance? I remember that being in front of the board. Does anybody else remember that?
You know,
I vaguely remember.
We've issued variances like this before. I can't recall.
I had one several years ago in Tom Nevers,
Tom Nevers.
where it was a husband and wife, and the wife passed away,
Right.
and he didn't realize, I think he owned the property, he owned an adjacent parcel, and he had no idea that had happened, and the end result was to keep them, acknowledge that they were separate, had always been intended to be separate, and the merger was completely unintentional.
Correct me if I'm wrong, but wasn't the tax assessor's office taxing them as separate entities at that time?
In the Gilbertson,
In the Tom Nevers?
yes, as is the case here, that the assessors has
So
been listing them as
I
separate
think
parcels,
that was
and
what we hung our decision on was that.
It's two separate tax bills.
Yeah.
No, yeah.
It's last sentence that Justice said.
Yeah, I mean, he calls out that the fact that the assessor's records had not caught up with the changes in ownership is of no zoning consequence in his opinion.
I mean, I'm not sure anyone's, again, sort of arguing that there's been no merger. That's why we're here. We've done all that we can do, but it's still, it's tainted. There's, again, even if for a split second in time, they were owned simultaneously, or sort of owned by the same person, under the zoning code, they've merged. And so the request is to, again, I think at this point, a variance is would be the most appropriate method to resolve or to grant relief if this board feels that relief is appropriate.
Does anybody on the board have any other questions?
What makes you think it's a variance? I know that we've done that before.
Well, 'cause it's not available under a special permit, and the variance can be granted in situations where the unique circumstances of a lot lend itself to sort of a specific relief that's otherwise ungrantable, I guess, sort of, or that you can't get to via special permit. It's sort of the catch-all, and that owing to the specific or the circumstances that created this issue, and not a general condition, but the very, very specific to this property, is what enables you to grant the variance in these circumstances.
I mean, I guess I'm stuck on when it comes to variance, is the substantial hardship, but we normally look at it in the context of tearing something down. We're here, maybe you're foregoing a gain, is that a substantial hardship?
It's loss of a lot. I mean, the mediated settlement agreement that was arrived at in Florida was based on the understanding by the parties and the Florida attorneys that these were two separately buildable, valid lots, and it was, this family, it seems, loves nothing more than litigation, and so this was not a friendly handshake deal. This was, I think, a hard-fought settlement in Florida, and based on, again, what has been represented to me by Gordon and is contained in the affidavit, if the properties would have been valued very differently for purposes of that settlement agreement, and the results of the settlement agreement could have been very different than what ended up happening if they understood that those lots had actually merged and were significantly less valuable as one than it was as two. And that was all part of what they had all agreed to going into this negotiation. And the Florida attorneys had absolutely no idea that the result.
Florida attorneys didn't do their due diligence, and these two
Yeah, for lack of a, yeah, I would say that, without wanting to throw the Florida attorneys under the bus, yes. They're not here, so I guess that's okay.
How do we feel about, I think talking about the Tom Nevers situation where we, use the tax records as a base, as a supporting to give that variance, being told by town council that doesn't get us there.
I think it's no surprise to anyone that the town sends out bills to properties that aren't buildable, and I have an unbuildable lot I've had for 34 years. I get a separate tax bill in it every year.
Mm-hmm.
Should we do a little bit, would it make sense to continue it and just look at those couple of the other decisions that we had done, given the granted variances on?
I have
Yeah.
Tom Nevers one.
I think we should do that, and I would like to, if we could, go back to town council and ask him specifically this question about the fact that, legally now, based on now it is in this 34 Dukes Road LLC, and that presumably reverts back to the date of the agreement. And does that get us there?
And just
That's
as
what I
a
have in
point
my
of,
notes, that was the question.
just
that
as
we
a point of
wanted.
clarification, if he comes back, if town council comes back and says yes, that there in fact is no merger, I mean, that's what you're asking him, if that's the case, then a finding of that no relief is necessary.
Right.
Yeah.
Okay, I mean, I just want to,
I think so.
make sure I understand the
I'm
question.
trying to get through it too, to get to the best answer for.
I found the prior decision. Coco,
Yes,
okay, so it was, decision 3515, it was granted in 2015, and the finding actually was not for variance relief. The request was for either variance or no relief necessary.
okay,
The board made a unanimous vote to deny the variance relief and found that no relief was necessary pursuant to the definition of ownership, which had been modified by a town meeting
okay.
amendment. So that's where we landed with that. I'm not sure what the difference is. It's a many-page decision.
That one, I believe the husband had filed a disclaimer to disclaim the interest of the wife that was to pass to him. And I think the reason we were here, if I remember correctly, is because the zoning language change had just happened, I think perhaps at the town meeting prior, and everyone was nervous about what that meant. And so we ended up here to confirm that I think the local attorneys were interpreting the zoning change consistently with the ZBA's intention. And that's, I believe, what brought us there.
Can you see if you can find the one on North Liberty Street? I don't know the address, though. Valmitino. Just be curious.
1 second.
Okay.
Do you have a recollection about when it might have been?
Well, it's before, that's probably a couple years ago, right?
I have a vague recollection.
Two and a half years ago?
Was that
Yeah, Arthur was
close?
representing, right?
Well, Jeff, it was before Jeff went into all that litigation about
Yeah.
trying to
Right.
move the house and the neighbors going bananas. And Ray went to he had to testify, and he probably testified a year ago, at least. I would think it would be a couple
I think
years.
it's longer than that.
I think it's more than 2 years.
It's 29. Okay, hold on. Just give me a second.
I guess my point being that if we think that the 34 Dukes Road LLC and the order takes us back to the date of this original settlement, then there's no relief necessary. Right? That we wouldn't have to get to a variance because If that goes back to the original date, then they never merged and there's no issue.
I found it.
Yeah, right,
Let's see here.
but we have a town council phone as of right now, merged.
Right, and so that's why I'd like their opinion on this amendment.
Which they didn't see, right?
Yeah, and I apologize. I thought that it had been included in the original packet, and it wasn't.
I
So
thought it
that's-
was included in
so
our request
that's my fault.
to them, so it's fine.
Are we choosing to continue this?
I think, Eleanor, you're looking for that decision just
Yeah.
to see?
But you think that you're gonna continue it anyway?
You denied the variance.
We did. And what did we, but I thought they got something. They didn't merge them?
You found
They
that
got
there
the
were
relief.
insufficient,
I mean, no
insufficient
relief.
grounds.
An opinion that relief wasn't necessary.
Yeah. I think it seems hard to write a variance.
You found that there were insufficient grounds to support a grant of variance, and that this, grant for relief was not justified. You denied the variance request.
Okay.
Okay.
So I think we should continue it and just get a clarification from town council. I know that's a pain, but I don't think he answered the question that we,
Well, I wasn't given a specific question. I was told just to ask him about the merger. So if we have a very specific question, I'm happy to pitch that to him. So maybe you can
okay.
enunciate exactly what you want me to get to him.
You could give him the motion to amend the mediated settlement agreement and the initial settlement agreement, and,
He had the initial one.
okay, well then, I guess, well, he said in his letter, didn't he say he,
It's right here.
I'm happy to provide him with the entire contents of the Nantucket probate court filing, if that helps.
he just said there was a reference to the original settlement, but copies of the original settlement and any deed thereunder were not provided.
Well, they were.
Well, so I don't think he understood what we were asking.
Frankly, this was lost. I put it through right after the meeting, and Libby went away on vacation, and when I reached out to them a few days ago, they said, we never got it. So they were very quick to turn around and produce this.
Mm-hmm.
If we follow up with another question, do we have to go through Libby? We do?
Oh, my God.
Can we do a document dump at the 11th hour, 41,000 pages?
But Susan, you had a specific question earlier, which I believe was, does this amended mediated settlement agreement, by virtue of that, is it unmerged?
I think it,
Does it
I
take
think
us
it's
back?
by
He was
that,
looking at the whole picture.
by the recording of the
Yeah, I mean,
confirmatory deed.
unfortunately, I think he answered a question we already knew. Like, we already knew that they were merged, but the question now, or I thought the question in my notes that I had, the question we were asking was, when the Florida amended, the amended mediated settlement agreement is filed, showing that instead of going to the individual, it goes to 34 Dukes Road, and therefore the control is separate, does that look back to the date of the original settlement, therefore undoing any merger that's occurring now? Because if it does, then you don't need to be here, and your title insurance company or whoever should be able to be okay with that. And if it doesn't, and they're still merged, then that's a different story.
So they could trust you, their attorney, in court.
Yeah, I mean, somebody should have done some due diligence. Do you want to email me it before you send it out, and I can just make sure that I articulated what I was trying to say? So I think we should continue.
Okay, so I'll make a motion to continue.
Okay. So I think, is it just the 5 regular, or Ed's not here, so Jim?
4 regular plus
Jim. Okay, so all those in favor of continuing?
Aye.
Aye.
Okay, so we'll continue
Okay.
talking.
I believe you have all the relevant copies, but I'm happy to provide extras or put together a special title package if you want to send it off to town council, if that would help. So just let me know. Thanks.
Thank you. You want to just do the next one?
You want me to get at?
Sure. Where are we now, on Brody?
No, 7A Hussey Farm Road. Oh,
It was hidden in there.
So, we're back to 3218, Jonathan G. Klatt and Sandra L. Klatt.
Yes, sir. Okay, Stephen Cohen for the applicant. What we have here is a inadvertent setback violation of a couple of stairs, and I'll walk you through it a little bit. The Platts bought an affordable housing lot, Nantucket Housing Needs Covenant subdivision. It used to be a former portion of 3 Manchester Circle. They also got a move-off house from East Bar Spring Road and moved it to this house, to this location. They made their dreams come true with a lot of blood, sweat, and late nights. The problem is the house is located 35 and a half feet from the front yard setback, but the inclusion of the landing and the stairs, due to the level of the foundation and the incline of the lot, is an encroachment of 1.7 feet into the setback. This actually was discovered during the process, but they thought it was cured. And I think you guys remember that at the time this was going on, this construction was going on, it was the same time there was a proposed bylaw amendment to change the setback rule to allow for an encroachment of stairs into setbacks. And it was either the board, I don't know if it was officially, or some members of the board wanted to try to limit that, and there was a limitation placed into the bylaw that I think was supposed to say no more than 2 steps into the bylaw, into the setback. But if you read it, it actually says that you can't have more than 2 steps, which I think is not really what was intended. And so the zoning officer, so when this was discovered, the surveyor said, oh, don't worry, we're covered, this bylaw just passed a town meeting, you're good. And then when he went for his CO, the zoning enforcement officer, I think correctly, read it to say, you have a landing and 4 stairs, so you don't qualify, even though you have only 2 stairs in the setback. And I argued with him, that's nonsense. Why does it matter how many stairs are outside the setback? It doesn't make any sense. And he said, that's not my job, which I actually think in this case is correct. So the nonconformity is created by the fact that because there's more than 2 stairs total, there's 4 stairs plus the landing, that it doesn't qualify for the 2-stair encroachment. So I have information about how this happened if you want to see it. Basically, there was a move-on application, and the move-on application is essentially pictures of the house and a site plan that shows a little box that does show 1 little stair. And then there's an HTC application from 9 months later that shows that it came back because they realized that the driveway, because of the slope, would need a retaining wall, and there's a driveway application for that, and then there's an application for the stairs, because at that time they figured out how many they needed. And it's just these little hand pencil drawings. The Mr. Klatt works for an excavation company. He was doing this all on his own. I think he did it remarkably effectively, but he was not up to the standards on this rule. And in fact, I think the rule just needs to be fixed. So what I would ask you to do is to grant a variance from the bylaw that allows for this intrusion, or in the alternative, you could grant a special permit because it qualifies for the less than a 5-foot intrusion. You'd have to make a finding that it was done based on a survey. He did do all the work based on a survey that showed the house more than 35 feet away, but of course the stairs were not really calculated until after they put the house on the foundation and then sort of measured it out. If you look at the original application, there's one little box there, and then later, several months later, they come back with the actual little drawing that shows several stairs. And at that point, the house was already set. So I still think we could call it an unintentional setback violation if you'd rather do a special permit, but really I think what happened here is that the bylaw itself is a little quirky. So that's the relief that's being sought.
Can I ask a question?
Sure.
For some reason, I thought that the change in the steps was restricted to certain zoning districts. Places that needed relief because of floodplain issues, things like that. This is not part of that.
No,
No.
it does restrict it to certain,
Yeah, so that's
And this is
immaterial.
R20 part of it?
No.
It's,
not exempt. R20 is not exempt, so there's certain districts.
So whether or not it has
yeah.
2 steps or 4 steps, it's not part of
correct.
that.
I think the answer to your question is that the exception does not apply in the R40, log 1, 2, 3, and MMD rules.
Yeah.
And I think that was probably your idea, that if
It
it's
was.
a big lot, we shouldn't be doing this,
Right.
but if it's a tighter lot, maybe we'll have the
Well,
limit.
if there are reasons that you need to do it because of floodplain and you need to add more stairs and things like that, I get it. But
Yeah.
if you're building on a lot that's this size or 3 acres or,
Right.
why would you want to be any closer to your setback?
Yeah, no, I think that's right. And this lot itself is only 8,000 square feet, 8,200,
Holy.
8,210, which is,
And it easily could have fit.
No, it could have.
Yeah.
And when he put it in, he was advised to put it back from the lot line. He put it at 35 and a half feet where he could have put it at 30. So it's not as if he intentionally put it at.
Well, you couldn't have put it at 30 because then definitely.
Then it definitely
wouldn't be
have a
violation.
Right. I mean, I think
So-
they actually, if you look at the pictures, where they put it is where it gets
Where are the
flat.
photos? I don't
What?
see any, are they in the staff report?
No,
I don't
we
see
didn't
any
get
pictures, and I
drawing.
also only have a site plan that says stamped survey to be submitted,
Yeah.
draft.
Yeah, we only have a
That's
few
an
pages.
email. These, here's 5 copies of the HDC approval of the stairs that have some photos behind them.
Those window walls weren't there, you could run the stairs in the other
I was
direction.
gonna say, yeah.
Yeah, I suggested that to him. Why don't we just turn them? But
Yeah, this is,
because of the window wells, it doesn't really work. So you can see where there's this little hand-drawn, hey, I just figured out I need stairs. And I'll show you here. I don't have multiple
And
copies
there's
of
the
it, but
landing.
this is the plan that was attached to the original move-on permit, where it's just one little box. See there? So they did figure out that they need stairs, but they didn't quite do the math. And then when they
let's see, I mean, 1, 2, 3, 4,
So that
5,
was
that's a
original.
lot of stairs
But
into
he
a
has
house.
on
Why
here
is it
as
so
one-
high
here's
off the
1, 2,
ground?
3. But he has them on this one.
5
He said.
steps?
it's
It's
a
on in
combination
here.
of the
I know,
topography
but he
and
doesn't
the
have the
exposed foundation.
Distance.
Was the exposed foundation approved by the HDC at that level?
It's, oh, well, I don't know.
I mean, it
There's-
Yeah.
should say right on the application what the
It-
exposure on the foundation was.
Doesn't
Yeah,
say.
unfortunately, because it was a move on,
Oh.
they basically has no information in it. You can see it's
Unbelievable.
It's
But why didn't they set it down? It doesn't look like the land goes higher in the back of the house. Why didn't they set it down 8 inches above the grade?
To get those window wells exposed.
it's
Yeah, I
yeah.
mean-
I think that what happened was they put the house on the flattest part of the lot and outside the setback, and then they built up the foundation. If you look at it, the foundation is a little unusually tall, and that
Yeah.
was to accommodate some nice windows. But what they didn't figure out was that the combination of slightly higher foundation
Did they do
and
elevations?
the topography was going
No.
to result in more stairs than they had space.
Right.
And I think, part of that was that John was essentially doing this on his own, and it was a little over his head. And again, when it was discovered, he consulted with the surveyor, and the surveyor said, "Oh, you're really lucky. They just changed this rule. You'll
This
be
should
okay."
never have been accepted by
But then the rule itself,
Yeah.
like I pointed out,
Unfortunately, I agree, Mark. I mean, the amount of information that was given to the HGC is,
Unacceptable.
yeah, I was shocked to see a signed COA that has no information in it. I get why they might not necessarily require elevations, but there's nothing filled out on that application.
Has there been any discussion with the building department to eliminate the platform and just run steps up to the front door?
There was, and they said it's a safety issue that they require that platform.
and what if,
Because of an outswinging door?
Yeah,
well, if they have a storm door, why don't they take the storm door off?
It's probably an energy code issue.
yeah. We've explored that. I've told them, don't, going to the zoning board is the longest, and most expensive, most complicated part of this. Can't we fix it with the
Right.
door and, change the grade, and he,
Yeah,
I
can
went
they
over,
change the grade? Why don't they
They
bring
have
in
to-
even
they-
more land?
well, they'd have to
fill?
mound up dirt. I mean, you could make a weird little hill there, but I'm not sure that we're really,
Or
that's-
extend the retaining wall. Did they
What?
get approval for the retaining wall and how high that is?
in the
For the
driveway.
parking?
Yeah, that was HTC approved, yes.
Where does that show the HGC approval?
I think the application that I handed you is for both. There's
Concrete
two,
retaining wall for driveway porch finish. There's no height.
it is the thinnest HTC application I've ever seen. I'm shocked that it was accepted, never mind
I mean,
approved.
How about getting rid of those window wells?
Well,
This one doesn't have the COA number as if it were approved, does it?
No.
This is just the application,
yeah, I
Oh,
have,
you know what? It might have been,
so we don't know what was approved.
right, you're right, because it says application received must act on by 10/21/17.
Yeah, it's not sign it. It's not-
Is the stoop the minimum size it needs to be?
Looks like it.
it's the 3-foot stoop, yes. I've looked at it with him pretty hard. Can't we eliminate the stoop? No. And the problem is if you get rid of the stairs and build up the what do you call it?
Yeah,
The
so get rid of-
ground, and you were to put in landscaping steps or something, Marcus still counts those because they connect to the entrance.
I'm just saying add 2 more steps at the retaining wall, at the parking retaining wall. He needs to get rid of 2 steps, essentially. And he makes it, right? He's 1.7 feet, so
Yeah.
that's 16 inches,
Well,
18 inches.
I think part of the issue here is that the bylaw allows for an encroachment of up to 2 steps.
Not
right?
in this zone, though.
No, it does in this zone.
Yeah, it does in this one, except for R20,
Oh.
R40, LEG 1,
So
2, 3.
what the reason why it's not
MMD.
qualifying is because
There's 4 steps.
there's more steps outside the setback, which I think doesn't really.
That's,
It's just I think it's poor craft drafting. And I talked to Andrew and Leslie about it, and they sort of said, "Oh, that's silly. We only care about what the encroachment is, not what's behind it. We'll fix that next time."
Right.
But really, the problem for my client is I encouraged him just wait. We'll fix it in April. But his bank is hounding him to get the CO and close out the mortgage. So he's got financial reasons why he didn't want to wait.
The 2 steps seems to make sense to me, your interpretation, I don't think it was intended.
Yeah.
2 steps total, so.
No, I agree. That's
Yeah.
just poor drafting.
Probably get fixed in time.
Yeah, I think it's just a drafting issue, and if again, like I said, I've encouraged him to just wait it out in April. It'll probably get fixed, but the bank is telling him that they'd rather see him close out the mortgage. It's expensive for him to keep that construction loan open.
Stephen, do you have do you have the approved COA from the HTC? Or just this application?
I have the approved stamped. Maybe this is.
I'm just curious to see if they made any comment.
I do have the approved one. Oh, no, I'm sorry, this is for the move on. We don't have the approved one for the move off, I just have the application.
Move on is the only one we care about because it should give us a ridge height.
Yeah, it doesn't, here's the move on, there's no ridge height.
This is unconscionable.
Well, it is a covenant, Mills.
So they get a break from,
Well, officially, I don't think they do.
No.
Unofficially is another question.
So and that's part of the problem was people were,
so it looks like a consent agenda item because it's only been signed by one individual.
yeah, it was approved on consent.
Well, how do we,
Linda Williams.
like to sort of begin to move on off of this? I mean, I don't think we're gonna solve the problem here. Are you fairly I'm just curious, are you confident that they're gonna amend that bylaw?
Well, I know that the planning
So
board
then-
is going to propose a fix to it, but that won't be till April. And he'd like to be able to get the CO and close out the permit now. It's costing him.
I mean, if the board wants to wait until after April, we could do that, or we can vote on it now. How does everyone feel? How do you feel, Kim?
I mean, I don't want, I'd like to give the guy more time, but the whole financial strain.
Yeah, I mean, I think it's pretty clear that was drafted. It was drafted not the way that, it doesn't read the way it was supposed to. I don't think this guy should have to.
All right, well then,
Pay for it.
that's fine, so let's vote on it. You prepared to vote on it?
So you could either grant a variance or you could grant the special permit, whichever you prefer.
Do you have any evidence to the effect that it was based on a surveyor?
Well, the house was cited based on a survey, but
Did he pin it?
what?
Did the surveyor pin it?
The foundation was done based on that, but not the stairs. The stairs
When
were
you
all
say
done by
based on that, did Bracken stake the foundation?
Yes, the foundation plan and the mortgage plot plan and the HDC all show the surveyed house, but the little pencil marks that show where the stairs were going to go were done by the homeowner.
Well,
And we don't know who set the top of the foundation.
Elevation state.
Yeah,
yeah, or anything. I mean, we don't even know that Bracken went out and put those four corners in the ground. That's
Right.
what I'm asking.
yeah. No, I mean, I don't know if you guys know John that he works for Toscana. He's relatively sophisticated with doing this, and he did a lot of it himself. So, he had someone pin the foundation based on keeping it far enough outside the setback, but clearly he didn't do all the math on the height and the grading and how many stairs he was going to need.
No, did we get the stamped mortgage plot plan?
No, whatever's in the packet is all I've gotten.
I believe that I have had that emailed to me while we were talking.
All right, well, maybe what we should do, if everybody's in agreement, is continue it to the next meeting and just get us the evidence that Bracken did what you're saying he did. And then we at least can
And that he
go the
pinned the
special
foundation.
permit route.
And maybe
Right.
HDC.
But what we can't pin on Bracken is who set the top of the foundation? Who put the grade stake in, if there was a grade stake, putting the foundation up as high as it is,
Yeah, no, I hear
which
you.
is
I
causing the
just sent it to
problem.
you, Alan.
Well, there was a mistake made, obviously.
Yeah, I mean, the mistake was not that the surveyor put the house in the wrong place. The mistake was
I
that
agree.
the foundation is too high, the elevation is too steep, and that math, I mean, clearly the HDC plans show, and I'm not trying to hide it, show that the steps were not calculated until much later, right?
Right,
There's
so
an
I
HDC.
think you're trying to figure out a way to make this a special permit relief rather than variance relief.
Right, I don't see the grounds for variance.
I don't either.
Do you?
Right. Right, so
No.
we're trying to give
An
you,
unintentional setback intrusion would be the only way I would be in favor of something like this.
Well, it certainly was set with the house pinned by a surveyor in a location more than 5 feet outside the setback without a proper calculation for how big the stairs were going to be. So who should have figured that out?
The
Should that have
elevation
been
height of the building.
Right.
concert with the grade.
Right, so unintentionally, based on the survey, failed to calculate the length of the stairs before setting it.
Well, again, it would be refreshing to have the evidence that, you know, at some point this was all calculated. Maybe Bracken had a different set of plans, and
He thought two steps.
He thought the 2 steps were going to work, and then the applicant just decides to put his house another 2 feet out of the ground, or 16 inches out of the ground. You know, that's not fair to the rest of the general public who abide by the rules. You can't just do that. So it would be nice to know that somehow this was a quote-unquote inadvertent mistake.
Well,
I'm sure it's inadvertent from the perspective that he would rather not be here talking about this.
yeah,
But I think we need something more to hang our hat on in terms of making that finding.
Well, I always feel more comfortable with some
well,
evidence.
I don't know what I could bring back to you. I think we have essentially
You
all of the
can't
facts.
get Bracken to say that he pinned it and had initially anticipated less steps, or, I mean, I'm not saying that that's gonna win over everybody on the board, but I think what you're looking for, Ed, is something that alludes to the fact that Bracken had been involved in that somehow something went awry after that.
Well, Bracken definitely did a plan that showed the house 35 feet from the lot line.
Well, if he definitely did that,
Why don't you
just
see
give
the
it to us?
plan that shows what Bracken had? I mean, at that point, wouldn't he have shown a landing of some kind? And some steps?
Well, the problem is the plan submitted to the HTC for the move on just shows a little.
No, I
block.
understand that, but if Bracken was going to stake it, he probably would have said, well, how are you getting to the front door? You need a landing or you need some steps. He should have a plan if he went out there to stake it, showing his points plotted on a plan so that he can go
Yeah.
out and do the staking.
But if that shows no stairs or 1 stair, you know, it's certainly not going to show 5 stairs going into
Well,
the
no,
setback.
I understand. I think we understand that it won't show this. Because then he would have set it back further.
Right, because at the time the house was set, that bylaw didn't exist. The bylaw that hopefully that should have cleaned this up but doesn't is several months later.
And tell me, why can't he bring in more fill and extend his stairs a little bit more from the parking area?
He could just terrace. He could go in 4 feet, put another retaining wall that's 2 feet high, put a set of steps in it, bring his grade up, put larger window wells, deeper window wells in, and solve the problem.
It would create a berm at the yard. I mean the house.
No. I think
No, it
what
wouldn't be a berm. Be another
Mark is
retaining
saying
wall.
is trying to put a retaining wall right at the end of the retaining wall that's there and create some sort of a terrace where you go up 2 of those steps.
It can be resolved if we don't
I mean,
agree.
there's not a whole lot of space in there, but I think, well, I don't want to speak for everybody, but it sounds like you don't have the votes to get a variance.
I also think you got, like, just this, you know, as part of housing Nantucket, you said it's a covenant house.
It's a covenant house, yes.
This, you know, owner was trying to do a lot of the stuff himself, probably to save money. I get that there was a mistake made. I think the bylaw is written poorly, but I don't. These are all suggestions that are going to cost this family
Just
more
give it up
money.
Because the building inspector, his interpretation of the 2-step.
Well,
Zoning
two things.
enforcement
The
officer.
building, the original plan was for less steps, and then the building commissioner said, no, you need a landing and then stairs, which is correct. And then the zoning enforcement officer, wasn't involved until we went in for the CO with the idea that this would qualify for the 2-step encroachment. And Marcus, the zoning officer, said, that says you only when there's 2 stairs, not 2 stairs in the setback, even though that's, I think, what was intended. So his interpretation is actually, I think, in this case, I'm quick to say Marcus has got it wrong, but in this case, I actually think the bylaw is poorly written and Marcus has it right. It just doesn't make any sense.
Then you're saying if Marcus had your view of what it should be interpreted as, he would have approved.
If Yeah, if the surveyors and everybody understood, and I think perhaps the board itself understood that what they were allowing is a two-step encroachment.
Right.
But the bylaw is written poorly. It says if you have more, it says you can only have 2 stairs, and this has 4 or 5.
And no one has seen defense Marcus.
Yeah, I tried pretty hard. I even went, above his head, and but everybody reads it says,
Right.
it's stupid, but he's right.
Yeah, I mean, that's what it says, so.
So
Right, so if we were to grant a variance, are we supposed to be able to say it's due to some,
you could say it's due to the topography. There's a pretty steep hill there.
after you jack the house out of the ground and mounded there is?
It's a very modest single-story home. It's a covenant house. I would hope you could see your way to not. It's not like he put the house at the 30-foot mark and didn't have all of his stairs in the setback. This is not an egregious violation. This is a guy trying to make it through. John and Sandy are not, abusing the system here.
I also think we might be able to get to the special permit, because it says, the siting of the structure was reasonably based on a licensed survey. I mean, the structure being the landing and the steps. I mean,
Well, that's what we don't have.
I mean, he
proof
very
of.
reasonably put the house 35 feet back. He left
we know the
himself
house
5
is
feet.
back far enough.
They just got the math wrong.
Right, like if the house, if I mean, Bracken put it where he,
But we don't know that he's. I mean, the only thing we're seeing is a draft of an as-built.
Well, it's
Doesn't it-
very hard to prove either way that the applicant didn't abide by a COA because there is no information.
Right.
So,
Right.
I mean, I guess we would have to, in that particular instance, take the applicant at their word that they did what they had always intended to do. So.
well, I think they didn't, I think what Stephen was saying was they didn't intend to have a landing and stairs, but then they were told they had to, and so they put them in, and then
Right.
found out it wasn't.
They knew they'd need stairs, but they didn't understand it would be this big. That came up later. So, they relied on the survey. The survey told them to put it at 35 feet, you'll be fine. And then they did, but the math does not work.
Well, that's all well and good, but you don't have any evidence that the surveyor said that.
So I think we
If
have.
he had a letter
Continue
saying,
with
we told him to
something.
put it at 35 because we thought the two steps didn't count, we could reasonably think that he relied on that
Unintentional,
info.
right.
But you're just,
I think you could reasonably make that finding based on the information that you have. And
there's
and
no information.
I know.
So I
The
don't
HDC
see-
didn't seem to care that there was no
Amazing.
that there was
Why
no
Why
don't
don't
you
you
just
just try
care.
to get the letter from Bracken, just saying, yeah, we thought that the 2 feet, you've said in your presentation that Bracken told the applicant that the two steps didn't count.
That was later, not at the time. When they did the as-built and they discovered, they said, "Boy, are you lucky! This bylaw change, cures the problem." But
But Bracken must have, when he sighted the house or set the pins or whatever he does, he must have known at that point that they would need access to the front door and contemplated that, right?
Well, what we don't know is what Bracken anticipated for the top of foundation above finished
Right.
grade.
Right,
Yeah.
but if
Would-
you were to
If
say.
it
I don't
was
even
10
know-
inches versus 2 feet, that's a whole entire different scenario.
Yeah.
Right, and so if he were to say, yes, I anticipated 2 steps and a landing, and that was gonna fit within the 35-foot setback, and then at least we'd have something knowing that he was involved and made some assumptions, and if then the assumptions went awry, then we at least would have something saying that he was involved to that point. It wasn't just this guy kind of taping it off from his, with a 100-foot tape from his driveway, saying, this looks about right. I think that's what,
Okay, I
Yeah.
can get something from Don. I don't, I'm
Let's try that. And
disappointed to delay it. I know they're very anxious about it, but I understand you're just trying to be responsible.
Okay, so, good with continuing till October 11th? Okay, will somebody make that motion?
I'll make that motion.
I'll second.
Uh,
whoever did.
Ladies first, okay, so Susan seconded that. All those in favor say aye.
Aye.
Thank you. Okay.
Okay,
3318 Paul J. Brody, 11 E Street for the applicant.
all right, Stephen Cohen for the applicant, and I apologize, this is my third of four today.
This will be the easiest though, right?
Oh, yeah, they're on.
No, this, that Eleanor's the one who teases me with that. This one I think is not too bad. This property, I don't know if you're familiar with the house, and I don't recall if there's a picture of it in there, but it's perhaps one of the ugliest houses on the island, and Nantucket will greatly benefit by its replacement. It's a 3-story house, completely inappropriately designed, and it's now being replaced with a substantially 1-story house and cottage with only a very small amount of second-story space. It's a much lower, more attractive, or more Nantucket feel house. The HDC has approved the design, but because the lot is a waterfront, it has a very substantial setback it has essentially no space between the front yard zoning setback and the Concom buffer zone. So the existing house and cottage and 2 garages were all within the setback, and we are substantially curing some existing nonconformities, but still need the front yard setback. And I can go through the details of it if you want.
Still need the relief.
The relief for the, yeah.
Yard setback.
Yeah, so we are reducing the front yard setback encroachment, and we are, we're gonna demolish both houses and both garages and one of the 2 sheds and alter the other shed, and then replace it with a house and a cottage and a garage, right?
Correct.
And then keep one of the sheds and alter it. And Joe Paul is the architect, is here if you have any questions about that, but essentially, except for the front yard setback, all of the nonconformities will be cured.
Right, it's over by ground cover.
And ground cover.
You're curing that as well?
What?
You're curing the ground cover?
Yes.
Yes,
Thank you.
So
And this
the-
has Concom approval?
it does.
Into the,
Look at the 50-foot,
comes right through the,
50-foot went through about 75% of one of the existing houses, the main house, and we flip-flopped the larger structure and the smaller structure so that the amount of building that goes over the 50 has been reduced, and the Concom approved it at the last meeting, and they issued their order of conditions last night.
Oh, even with the wood patio.
Yeah.
Yeah, it's the first time they've ever approved the wood patio.
Yeah,
Part of it
because-
is because all that, I don't know if you guys see the green area. it's
can you
all-
identify yourself, by the way,
Yeah,
just for the tape?
Joe Paul, I'm the architect on the project. Right now, the 2 houses have a mowed lawn between the structures going all the way down essentially to the water line.
Oh, so they use that square footage as
Yeah,
part
so
of it.
we've added about 7,000 square feet of native plants right up to the house. And that's why the HDC bought the boardwalk idea, because we've eliminated the lawn. And the Concom, they'll allow a patio over this, but they won't allow a deck. We have a wood patio, which is essentially the substructure of the deck is crushed stone, and the deck sits on purlins and doesn't have footings under it. And Bracken did a calculation about the permeability of that deck. The spacing has been widened and so forth. So it was all approved. We certainly couldn't move that structure any closer to the water. And in the design, we did reduce the size of one of the garages. It got cut by about 25%. It's in its current location, literally sits on that spot. And then the other structure, we pulled back in a couple feet to improve the front yard encroachment. And then the overall design reduces ground cover, and it also reduces the building height. I think the building height now is
Yeah, it's over the height limit. So we're curing substantially all of the,
The existing building is over the height limit?
yeah, the proposed building is mostly 1 story.
Is it the cupola?
No, it's,
Cupola doesn't count.
Yeah, this isn't, sorry. The cupola is really more of a monitor. It runs from almost me to you and is an actual physical room up there. So the ridge length on that thing, I think, is 12 feet. It's actually a gable that runs along that ridge.
so
So it looks to me like there's actually much more in the front yard setback than there used to be. Is that correct?
I think the volume of encroachment is increased, but the distance is decreased. Is that right, Jeff?
No.
Can I show you this?
Yeah.
So, we did, everything blue is two-story. Everything that was built, where's the best place to do this?
Right in the middle here.
Okay, so, here's the front yard setback, right here.
Yeah.
So everything that we are doing that's new conforms to the front yard setback. There was an existing garage right here that came out to there. We're making it smaller. And then this little piece right here used to come to here. We've moved it back. So that nonconformity goes away. The shed is nonconforming, that stays.
So this is the only.
Okay, I must have been looking.
Yeah.
This is the setback line.
Yeah, right there.
Yeah.
Yep, that's, and the septic is in here, that's been approved. So this piece was reduced, and then, see that right there, that gray area, that piece was pushed back. So that front yard conformity, or non-conformity, was made a little bit better, and the square footage of the non-conformity was reduced here. But the bulk, anything that's built new, from here all the way through, that's all conforming
Okay,
to the
so
front
this
yard setback.
conforms right through there. All right.
Yeah, it conforms.
I
Yeah,
was
yeah,
looking
yeah.
at
It's
the
the-
wrong line.
And then, this is the 50-foot setback right through right through here.
Right, the line is right there.
Yeah, and it's hard to see on this, but the old house is this other gray area. So the former house was conforming to front yard setback, but the two houses were here and here,
Right.
right? So
Yeah.
we're connecting to something that was non-conforming, but all of our connections over the front.
It's just
yard
interesting
setback.
that you can build this deck raised.
Yeah, well, you can do a landscape, well, it zeroes out at the grade here, and it gets to about 24 inches there. The grade and the deck zero out in the back, so it's essentially a landscape wall. So if you had a patio with a retaining wall,
You usually can't do that within 50 feet.
they,
Well, that'll be a new
the Concom.
new era at the
approved it.
Concom.
Yeah,
The,
I'll have to remember that.
Yeah.
All right, there was some mail on this one.
Yeah.
yeah, there was one a butter.
Permeability is probably key to that
Yeah.
success.
So I think also the reduction of the nonconformity and the revegetation of that lawn was a substantial
Right,
trade.
and I think they look fondly upon having a structure like that that limits where you really participate in the backyard in terms of entertainment, as opposed to sprawling on a lawn or some other.
That's right. They like
that was the only reason why the HDC or the Concom approved it. So the client's lawn area is actually, doesn't have a water view, it's blocked by the house. If they stay contained to that boardwalk area.
Right.
And I read the order of conditions, from my understanding, they're requiring that the landscape get maintained for 3 years with a performance bond actually attached to that, so that the plants are,
Healthy.
there's no irrigation in there, there's temporary irrigation until the plants take hold. But anyway, it was a unique writing for that.
Yeah, I think the Concom was pleasantly surprised that someone was willing to give up that much volume of lawn encroachment into the wetland setback. So they were willing to trade a little. And no pool, right? A butter, or I don't know if it's a butter, but there was a neighbor who wrote in who basically complained that they didn't like the design. They didn't think it was Matackety enough. Frankly, the house that's there now couldn't be less Matackett, and the house that's proposed couldn't be more modest in terms of volume and size and height. So I don't totally get where they're coming from on that, but that was the complaint. That
You
they
don't
didn't-
have the before and after in our packet, right?
on
Well, you keep telling me that the building is the ugliest building on Nantucket, but I
Do you
never
know
go
where
to
Lloyd
Natick.
Arnold used to live?
Oh, yeah.
This is Lloyd Arnold's property.
Yeah, I know the property.
No offense to Lloyd, I like Lloyd a lot.
There was a variance
It was pretty unique.
project years ago.
it was what?
There was a variance issue.
There was, yeah. There was for the garage.
Yeah, and it took a long time.
By the way, in
To get
terms
the
of
variance?
review with the HDC, Matic Advisory, I met with them, we had, this thing I think made it through HDC in maybe 3 meetings. It's pretty quick, and Matic Advisory was actually, once they understood it, I think they really liked the whole boardwalk idea,
Right.
and the fact that less than 50% of this is 2-story.
Steve, what was the height, conformity issue? What was the difference there?
The current building is non-conforming and the proposed
How
building,
high is it?
30,
The peak is at 38.39.8.
yeah,
Is that above finished floor?
It's gotta be an elevation.
Yeah, above elevation 12 roughly.
Right. Yeah, it was about, I think my recollection was like 27 feet.
That sounds correct.
27.
yeah, okay, so I have it here, it's
39 something
27.7,
minus
but
12 is 27.
And it's now 25 feet there?
25, yeah.
And what's the new height?
yeah.
24 and a half is viewed from the water and 23 and a half is viewed from.
So it's under the 25-foot ridge height limitation that's being imposed.
So the only thing you're requesting is really the front yard setback.
Yep.
Correct, yeah.
Yeah.
And again, that's for the garage that's smaller and the shed. The
And
house-
the neighbor is asking for no construction, but we would normally not restrict this construction time frame in this area.
We don't do it in Nantucket?
For your information, that letter, I don't think the neighbor.
Yeah, I couldn't see him. and he-
9D Street.
The
I
direct
know, he's on
abutter is a
the,
family
he's on the
member.
abutters list.
9D Street.
9D, it's on the list.
Okay.
Yeah,
Down at the, it's sort of midway.
right, so the direct abutter is a family member and,
Paul Merrithew. See it? So he's, may not be a direct abutter, but he's on the
On the
list.
list.
so.
Yeah, I mean, it's
uh,
tight
yeah,
in there. There's no question about that. Steven, do you want,
If we don't normally restrict it,
those are from the previous thing. I don't know if you want those back.
is everybody's okay
As
with
far
it?
as I know, we only restrict residential on historic district.
Ensconce downtown.
Right. SOD,
That's it.
SOHD,
It's fine with me.
ROHD.
Fun makes
So
a
I'll make a
difference.
motion to approve the relief as requested. It's a special permit, right? Yeah.
Correct.
A second.
All right, any further discussion? Now, so the regular members vote, please. All those in favor say aye.
Aye.
Thank you. Okay, 3418, Jonathan Wraith, trustee of 14 Easy Street Condo Trust.
I'm gonna sit on this.
Okay, so
14 Easy Street LLC.
Stephen Cohen for the applicant, my last one for the day. And I think what we have here is the fourth application for this property. We originally came in to alter a pre-existing non-conforming structure, and then we had to come back because the original application only allowed for renovation, and we ended up doing a demolition, so we needed to have the language tweaked to get that building permit. And then there was some issues with the design and the height, so we had to come back to have that clarified. And this application is about a second parking space. The original permit provides for, or the approval provides for maintenance of the 20% open space. And at the time that that permit was issued, that was the bylaw. And I had this, this lot actually was, I don't know if you remember it before it was altered, had a significant amount of brickwork and other things on it that it was actually not in compliance with the bylaw at the time. And when we applied for the original application, I had applied for relief for that to include the overage and then more so, and then between the application and the decision, the owner actually changed the application and decided to reduce the amount of hardscaping and to increase the amount of open area. So I had told the board, we don't want that relief anymore, we're gonna be in compliance with it. And I think there was a notion of, okay, great, we'll take that into consideration. After that happened, the zoning was changed and the 20% rule was eliminated. So it's I could take the position that we don't need relief for that, but because there's an existing permit that says you have to be in compliance, I'd rather get the board to, it's a little funny, it's written a little funny, it says we have to be in compliance with the rule as it's in the bylaw, but then the bylaw says you don't need the 20% in this district. So it's a little unclear as to whether or not how you would read that as requiring 20% or requiring 20%, but not here because because of the way the amendment works. Because the amendment doesn't eliminate the 20%, it just says it doesn't apply in this district, but of course the house is in the district, or the building is in the district. So the building has since been converted to a 2-unit commercial building and a 2-unit residential building. There's 2 commercial units on the first floor, and the second and third floor are residential. Even though there's no parking required in the CDT district, the owner would like to provide 1 parking space per residential unit, and most residential units would like a parking space. The inclusion of a second parking space would lower the open space to 19.2% instead of 20%. So it would be way more than what's required because there's none required, but it's 0.8% not in compliance with the original permit, which was issued before the bylaw change. So what I would like you to do is to either determine that the bylaw change in the way it's written means that we don't have to, that we're already, no relief is needed, or you could determine that because the bylaw was amended to eliminate that condition in this district, that you would also drop the condition. Or if you don't want to go that far, you could just lower the condition to allow for conformity with the application, which would be a 19.2% open space, or I'd actually ask you to go to 19% just to have a little leeway. But that's essentially where we are. We'd like to get a second parking space, and there's nothing in the bylaw that prevents that, but the original zoning decision raises some question about it.
Okay, so where is the other space? Right next to it just makes the existing one wider?
Yeah,
so
correct.
two
They
can
they
fit
would
in
be,
there?
they would just be next to each other.
Got you.
The other thing is, I think it was the staff report suggested limiting the spaces to residential use as opposed to commercial or whatever, and that would be fine. The condo documents already do that, so it would only be in conformity with the deed restrictions that are already in place if we wanted to do that.
All right, so I was writing, but I missed number 2. We could determine that there's no relief, according to you.
Number 2 is omitting condition.
Just omitting the condition, okay.
Yeah, one would be determining that because of the bylaw change, that no relief is needed. The second one, which is, an interpretive decision. The second one would be saying eliminate the condition, so there's no open space requirement. And the third one, which is what's the case for the rest of the district now. And then the third one is just lowering the open space requirement.
Okay, so how does the board feel about this one? Or do you have questions for Steve? Anybody down there? No?
No.
Susan? No? So what would I don't have any problem with probably any one of the 3
Me
choices if we wanted to put a condition on the space being restricted to the exclusive use of the residents therein. We probably want to go with number 3, which would lower it to 19%.
think-
And
Or
at
would
this,
you do number 2 too, right?
You can still eliminate it and have that condition.
okay, so we can eliminate it, but add that condition to it.
Yeah.
That's what.
Although, I like this open space right now.
Yeah, it looks good.
It looks good.
My preference would be to just reduce it by whatever.
Yeah.
Is that what we're
Yeah, to 19.2,
Yeah.
rather
Oh,
than allow
19.
them to 19, rather than allow them to not have any requirement.
Right,
Yeah,
okay,
that's fine.
3?
yeah.
So modified.
And then with identifying those parking spaces for residential use.
Right.
Yeah.
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 So the recorded condominium documents already do that. So the condition is not, to make it simple, I'd say that I'd want the condition to allow us to use that existing restriction as the way to do it instead of requiring something new, if we could just phrase it that way.
We don't know that.
We don't have
We don't
that
have those
document.
condo
What?
documents. We don't have those condo
Yeah,
documents.
I mean, just, okay,
But this would allow the zoning enforcement officer to enforce.
to enforce it, yeah,
as
okay,
opposed
so that's
to
fine,
condo
Okay.
docs. I think it's better to.
Yeah.
Which can be amended.
yeah, okay, that's fine. It's not it's not gonna change.
Okay, so should I make that motion?
Sure.
To approve the relief as requested by, hold on, where's the number 3?
So it'd be a modification.
Be a modification to reduce the open space to 19,
Can we get a 19%?
19%. And to restrict the 2 parking spaces that'll be on the lot for the use of the residential units on the second floor.
And to leave the rest of the decision in full force and effect.
Yes,
Decisions, they're free.
yes.
To leave the remainder of the decisions in full force and effect. So we're basically modifying a condition, the remainder of the relief remains in full force and effect.
Yeah.
I'll second that.
Okay, the motion's been made and seconded. Any further discussion? No. All those in favor say aye.
Aye.
It's unanimous, thanks.
Thank you very much.
Who's voted?
Jeff didn't vote.
Just a minute.
He thought he did. Okay?
All right, back to the brusher.
3518, 79R Orange Street LLC. 79R. Is Michael coming back?
I'll go ahead.
I'll get it.
Okay, not good for me.
Get that hip moving.
You can vote next, Jeff.
I'll go to the restroom. Can I do that?
Yeah.
Jeff can sit.
All right, we're going to take a brief break.
No, Jeff can sit.
No, we all can sit, but we'll wait for you.
You have to give to Ed.
I don't have to go that badly
All
then.
right, then let's go.
My God.
Are you sitting on this?
There's enough people.
No, no break. That was a fake out.
No, well, there's enough people. I figured you would just continue the meeting.
No.
You're not going to be this mean, are you?
I think
No
it's
wonder
my
the meetings
email
last
side.
5 hours when Ed chairs.
3518, 79R Orange Street LLC, 79. Oh, Terry. All right,
So
let's
we're having
take
a break.
Having a
break.
break.
Quick break.
Sorry, John.
You want the cheese cracker? That's 6.
I have the worst headache of my life.
Is it because of the cold?
No, I've had it for 3 days.
Oh, really? It's a migraine. You gotta start smoking pot.
No, I don't do that. I think it is a
Gummy
migraine.
bears. Marijuana gummy bears.
No, now I'm just having, today all day, I'm just having like water. And yesterday tried caffeine, I tried Advil. I just want to go to bed.
Botox. No, I'm serious.
What is that
For
gonna
migraines.
do? No, I
It's-
think
it's a
this is
treatment
the
for
first,
migraines.
I've never had one before though. I don't even know if that's it, I just have a horrible headache.
Sinus.
It's not
Yeah,
sinus.
sometimes when it gets so cold, my sinuses just react and I get a headache.
I have allergies, but this is different. Whatever. So I got a text being like, oh, so your conversation before the meeting was interesting. I'm like, what, about the vodka and the apple? I'm like, what are you talking about? I have no idea. I'm like, vodka and apple? And I'm like, oh, yeah, Mark said you brought vodka and you said you brought not an apple. You gotta be careful. Those microphones pick up everything.
Did I say that?
Yeah.
No shit.
We were kidding, but I mean, before the meeting even started, we were standing up and we were like, I was like, oh, did you bring snacks? And I brought vodka, and I was like, oh, I just want like, we were obviously kidding, but it was funny that I got a text from someone watching at home.
I don't need Nicole saying it.
I know. I was like, what are you talking about? I had no idea what she was talking about. Then when she said, I was like, oh yeah.
That YouTube thing. I don't think it's as good as the other one.
Well, I don't know about that, but we watch things.
Oh, it should be recording.
And they're not doing the HGC anymore, right?
Is that right?
I don't know. They weren't for a couple weeks doing the HGC. It was terrible.
I know the upstairs doesn't stream, but I thought the downstairs.
What's the YouTube thing they said?
It's a link to YouTube videos now, right? It's a different website?
Yeah.
Okay, we ready? Go ahead, John.
All right. Good afternoon, Mr. Chairman. For the applicant, 79R Orange Street LLC, Attorney John Brescher. What we have before us is a special permit request and a rescission request for an existing special permit. By way of background, we represent the applicants, 79R Orange Street LLC, the owners of 79 Orange Street. 79R Orange Street was subdivided earlier this month, earlier in August, under the 4181L bylaw provision. They received a endorsed planning board A&R plan in February 2016, and it was recently recorded. As way of background, the locus, which was 79 and 79R Orange Street, was the old Nantucket Bake Shop, and it's a commercial use that pre-exists the adoption of the zoning bylaw. In 2014, we were before this board to convert the use from a bake shop to a yarn store. We received relief in that decision, and that relief included that it may be converted from a bakery use to a yarn craft retail store. With the apartment in the rear of the structure, the apartment shall be limited to year-round occupancy, hours of operation, and any alteration of this retail use shall require additional relief from the ZBA. In the initial application before the board, we had requested to convert the commercial garage to a residential dwelling. We received pushback from the neighbors and abandoned that, and the decision reflects it as such. Since that time, we have subdivided under 4181L. We've reached out to the neighbors, and I actually have a letter that I can submit for the file that they are not opposing this under certain conditions. And so more to the point, what we have now is per the 4181L subdivision, the lot that has the commercial garage on it is now it's a pre-existing non-conforming lot, and more interestingly, it is a pre-existing non-conforming structure and a pre-existing non-conforming use because it is still regarded as a commercial garage. The intent is to effectively renovate the structure, put on an 84 square foot addition in the back, conforming to the setbacks on one side, no closer to the setbacks on the other side. Have it still be single story, bring it up to code, and have it be residential use. Because it is a non-conforming structure and a non-conforming use, even though residential uses are allowed by right in the ROH district, because it is the pre-existing non-conforming structure and use, it would need relief from this Board of Appeals to convert that use and to bless the addition. The other interesting part in this is that as this is now a separately marketable, buildable lot in a separate ownership, separate title ownership, there's no reason to have the commercial special permits associated with this property now. And so to that extent, we would like to rescind the conditions of those two ZBA decisions only as they relate to the new locus, since it will now be totally residential. I apologize. Also, we weren't sure if a parking waiver was going to be necessary. I do have a proposed and existing conditions site plan that was just handed to me probably about an hour before the meeting, that shows that they can fit 2 parking spaces on that area, which I'd be happy to submit for the file, as well as the agreement with the neighbors. And just so in that instance, I don't think we'd be asking for a waiver necessarily. If anything, it would be to bless the existing parking that is there now and have it continue it to have 2 parking spaces for this portion. So I will gladly hand in those attachments and exhibits. And what was that? Yes. Okay. And so and then to that extent, we would withdraw the waiver for a parking waiver. And so effectively, the argument here is that because it is a pre-existing non-conforming structure and pre-existing non-conforming use, being the commercial garage, is being converted to a conforming residential use, with the addition being in the back, being no closer to the lot lines and outside the setbacks on one side, that this would be in harmony with the purpose and intent of the bylaw, since it would now be a conforming use. And if I may, I do have enough exhibits for everyone, so I will, with your permission, I'll submit them to the record.
Yes, please.
Okay.
Oops. Thank you.
Copies of the agreement between the neighbors. Sharon. And that's where we have the proposed conditions plan showing.
Boy, nothing like the last minute.
You can smell it, right?
Well, the Alcenso will not speak against your application, which is scheduled to be
Zero
heard.
draft machines.
Yeah, this
Come right up.
afternoon.
Wow.
Okay,
And the owner is here if you have any questions as well.
I have a couple questions. So the Ostranders, is that their name?
Correct.
Did I get that correct? We have another application in front of us on Westchester Street where we have been going around and around about permission from the neighbor to actually work on the side of the building that is this close to a lot line.
That side is concrete block, though.
Well, I see that, and
So
so my question is the garage basically remaining intact?
Hi, it's Matt Fee, owner. Yeah, the garage will remain intact. We made the designs. Architects were telling us to go up and make it bigger and do all this other stuff. And we, in deference to the neighbors, we made the design with as little impact on them as possible. There's one window added to their side. We're not going up. We'll go up like 4 inches maybe to insulate, but we're not changing the outside of it. We're not changing their view. The parking staying the same because they are the closest abutters, and we've agreed to not make any changes to it, while they're still living there, if we ever do. It's going to be used by my daughter, probably year-round housing for her. We're going to get her out of the house. She's 25, so that's a good thing. But yeah, so I don't think we're going to have to do a lot of work on their side of it. We'll have to do some work on the roof and on the other 3 sides.
so she'll access along the east side to get into the house.
Yeah, she'll go in between the 2
The
dwellings.
yarn
Yeah,
store
she
and
won't.
the-
Yeah, she'll.
yeah.
Yeah.
I'm just curious, is that kosher from a building permit standpoint that you only have 1.94 feet you get between the building?
Is that this dimension here?
Yeah, I'm just curious because that seems.
My sense is, Mr. Chairman, if there's a change of use, it's going to be a dwelling unit, they're going to have to fireproof that concrete block unless it's got a fire rating that's being certified by the architect.
Yeah, no,
He's talking about the
I'm
alleyway.
talking about on that corner. Let's say the new owner of the. I know this isn't happening,
Yeah,
but
no.
hypothetically, there's a fence going down that lot line. And one of the egress doors is on that side.
It is.
How do you get from there to the street? It's only 1.94 feet wide. I'm curious if that's a building code issue.
Well, that's what I was asking, just because then you would have to make the garage non-functional and go through the garage. Who knows?
Well, the garage is non-functional.
Well, I mean.
It's being
what-
converted
what-
into a dwelling unit.
No, he's saying they're keeping the garage.
The garage is turning into the dwelling unit.
Oh,
They're
I thought
keeping
you.
the structure of the garage.
Got
and
it.
working
And you're
it
leaving
on
the doors to make it
inside.
look like a garage,
Yes.
but
Right,
it
but
is.
that's one of the egresses. The other is the.
Well, there's 3 doors. There's one in the back, there's one on the
No,
side.
the 2, one will be on the side and one will be in the backyard.
So
So
I
I-
misunderstood him. I thought, okay.
So I'm just curious. Again, it's not even.
Well, no,
necessarily
because they have
this
2
app-
means of egress then. It wouldn't matter if this
So
one.
you can get to your backyard.
Well, you could use that to put to get your trash bin. You don't need it to egress the property in case of a fire. I don't think it matters.
Once you get out to grade, you've met the egress requirement.
So you can be in your backyard and
You
trap.
can be in
your-
the, climb over the fence or whatever you need to do.
Gotcha. Okay.
And I think the other issue, I think, is that we may have to firewall the wall.
You will.
Yeah, the one wall there will have to be fireproofed
Closest
between
to the
those two
yard shop,
buildings.
yeah.
A new window.
Yeah, exactly. So those will have to be.
Well, the question is, do you have to go on the Ostrander's property to do any of this work?
No, we don't.
How we do the roof?
Physically, you can't do any work on that side of the building without.
Yeah, it'd be tough to roof it.
Well,
put on a new
we may have
gutter.
to, we may have to put a ladder up and do the work. We're going to try to do it this winter when they're away. They understand, you know, if this got dragged out, they understand we might be there next summer. If we had to come completely up to code, we may have had to knock it down and start all over again, which could have been a lot more, you know, a lot more onerous on them. So
All I'm saying is you should get a note, we would require a note from them saying you have permission.
okay.
Because I think we need to be consistent. That's what we're asking that other applicant to do.
Oh, the other application is much more invasive in terms of the amount of
Right.
work they're doing.
Right.
But I'm not disagreeing with you. I'm just saying they're not
It
really
should
the
be
same
common
scope.
practice
But
that
if
we-
you, yeah.
Well,
Something
again,
in
I mean,
there.
then we have to start parsing, oh, well, that was 10% of
Right.
this one, and
Right.
Fine.
so you get 10% of the letter, maybe. I don't know.
That's fine. I wasn't saying that I was against getting the letter. I was just pointing out that the scope of this project is pretty limited.
No doubt, but you
Yeah.
still
Oh,
have to
it's
go
fine,
on your
it's fine.
your neighbor's
fine.
property. Go ahead, sir.
To your point about the distance between the garage and the property line, both properties are owned by the same party, is that correct? Yes. So you could create an easement for the person to get into that new dwelling.
Yeah.
Okay.
Yeah, no doubt.
Sure.
I was more concerned if they were, and I know they're owned jointly now, but if they weren't.
Well, later there'll be an
Yeah.
easement in place.
Yeah, I would think there's gotta be an easement in place.
Somebody can walk
It's a
across.
good question. What
Should we-
if the building
they're
department
both
will
owned by the
require?
same
I have no idea.
It makes sense to put one across.
Yes, yes.
It's common, it's 79 Orange LLC and 79R Orange Street LLC. It's
So they're-
this.
they're
So they're
Separate owners.
separate owners, but for all intents and purposes, I'm pretty sure we can grant an easement.
Why are you asking for a waiver of parking?
He's
We
not.
They're
we
not
weren't
anymore.
we
They
weren't
were
sure at the
through
time because we didn't have, if you look at the date on the site plan, we didn't get it until today. So we weren't sure if we needed it. So now we can withdraw that waiver.
Are these compliant spaces?
They're 9 by 16s.
As opposed to 9
So
by.
now 9 by 20, but even though they've existed and used for the last.
And you need two?
No, it's just simply showing that you can fit those two on there.
But wouldn't you still need some sort of waiver, Eleanor, in terms of the spaces not being compliant?
I would think so, because 9 by 17 or
9
8
by
by 17
16.
is the smallest.
7 by 17 is compact, 9
Seven.
by 20 is dimensionally compliant with the parking requirements. But
So
you may remember last month,
Right.
another application was requesting one 7 by 17 space. And it was determined that, once again, the way the bylaw is written, does not specifically preclude that one space can be compact, that the one space provided.
Well, even if you provide a one compact space, you don't have the length to provide one regular
Correct.
space. Here.
Well, but you don't have the length this way. You'd have to go this way.
Yeah, you'd have
for
to
the
parallel.
one.
parking.
So
Then you can
could
do
show
9 by
the one
18.
compliant space.
Right.
But does it isn't it pre-existing non-conforming?
I don't know. That's what I'm asking. I mean,
No, it
is
wasn't
the-
residential.
or is it-
Oh,
And
okay,
you
it's
could,
commercial.
you could grant relief to the extent necessary within the body of the decision from the requirements of 13918B and A, for that matter, that have dimensional criteria. Because it's physically impossible to do otherwise, it won't, harm the neighborhood, and it's within the intent and harmony of the environment.
And
We
this is where vehicles are parking now, I believe.
Yeah,
Yeah.
I would say,
Historically, there's been two spaces that have been used when the bake shop had it, and they're still being used now. And part of what the neighbors were happy with was we weren't changing that everything was staying the way it had been. So,
And the
talking
band
more- a
is
little bit
on
more
the
on the
side of the
technical.
And the
building
band's still-
in
yeah.
concert with that.
Yeah,
exactly. So there's really
three
three spaces like
Yeah.
along the side, and they're all, technically not legal, but they all are off the street and
Yeah.
work.
Yeah, I remember that.
Question for Mr. Berkshire.
Go ahead.
John, when you were the administrator for the zoning board of appeals, which is what, for 4 years?
For 5.
5. Did you ever figure out why you need to go before the zoning board of appeals to go from a non-conforming use to a conforming use?
No. It is one of the great
Should be a
mysteries that
matter
I've
of right.
never been able to
I
unravel.
think that maybe as a representative of the Bar Association, maybe you
I'd-
could take that upon yourself.
I would be
to bring it
happy to.
in front of the town fathers?
Yes,
Thank
by
you.
all means.
All right.
So you want that letter
Well, I
as,
think the letter, I think we should be,
are we gonna base and approve, are we gonna continue it, or are we gonna base it on getting that letter?
Approve it with the.
Letter being,
condition when the letter gets produced
right,
prior to the,
prior to the signing of the decision.
The letter from the Ostrander?
I think
Yeah.
the letter should be, we should be supplied the letter beforehand.
before.
So the Ostranders don't feel any pressure that it's been approved anyway.
That's up to
I mean,
Would we be putting restrictions on
1 month.
construction on this project?
I think
Yes.
so.
Okay, so I didn't know how that would impact what they're trying to do and when they're trying to do it. If a delay for another month would impact their permitting.
I don't know, it doesn't look like the addition's terribly big. I mean, it wouldn't seem like
No,
it's
it's
80.
the roofing and trim work and other things that would be done, windows, doors.
I think it's
I
a
could get it.
function also of hopefully applicants will get the message that you should come in with this kind of stuff ahead of time instead of us requesting it. And then,
Okay,
That's fine. I mean, it's kind of common sense. You know you're gonna have to access the property.
Right.
You know you're gonna be, there's gonna be ladders, there's gonna be staging, there's gonna be all sorts of stuff going on.
Well, there's
Because if the Ostranders,
liability.
if the Ostranders for some reason said no, then we'd be back here saying, oh, well, we didn't really mean it. So why don't you just get the letter and then we'll,
so should I make a motion to continue?
Can I
Till
speak to
October
that real quick?
11th.
One of my concerns, I'm not sure how long it's gonna take to get through the building department, but, and whether they'll have some of these questions. One of my concerns on the timing is that if we are held up, that this will drag, all this stuff always takes 2 or 3 times as long as I think it's gonna take. And I'm worried that we'll impact them more. I'm kinda hoping that if we get a letter if we need to be on their property. You know, if we can do it without being on their property, if we can access it from the other 3 sides, that would be, we could get right into the building permit, right into the building office and keep going on this.
I was always under the impression that repairs and maintenance,
Mhm.
you wouldn't have to get a letter from your neighbors, because I know.
It's a matter of right.
When my neighbors have, they've done shingling, they've done painting, they've done repairs where they've taken out the windows and plugged other ones in. They go ahead and put their ladder up. I think it's by right, for repairs, for new buildings, yeah. Okay.
well, the new building is outside of the setback.
Right, they'll be able to get to that.
I don't know the answer to that. I mean, I hear you and I've sort of heard the same thing. I just, argue.
Well, can I make a suggestion? Wouldn't you be able to go to the building department for a permit to make the exterior changes but not change the use?
Exactly.
So get your permit going so you can start that part of it and then we can amend
your
it.
permit
Yeah.
to change the use.
Or show us that you can, as you said, just go on and do, because arguably what you are doing on that side, you're not changing the roof wrap.
No.
Just some
No.
trim
He's
and
putting
some
insulation on top of
Maybe
it,
some-
it's gonna elevate the ridge height.
Is this inside the setback?
It'd just be nice to be clear on that.
Yeah.
I
I think that's a good thing for Eleanor to
But
research.
if it is inside the setback, you're gonna leave, you're altering it, it's not from the structure. I'm just saying, if you want to issue a building.
So we'll
Oh, wait,
pursue
can I-
it for another month
He can
and
issue
try to
it for
make
some of the
sure
work, but maybe not all of the work. In the interim, he'd be able to
Yeah,
get his
you-
relief.
What he would do
and
is
then
not,
amend the permit accordingly.
yeah, not permit the addition if the addition is, you would permit
Whatever
the-
work he could do and justify without relief, he could permit.
Yeah,
I mean, we've held up the other applicant for a good 6 months.
And there would be
About the
no
letter,
restriction
so-
on the time.
I think we
Because it
should.
wouldn't be something before us.
It's an existing foundation that they're going up, you know.
But they're going up
there's
2
a wall,
stories.
And then they're going up from there.
Yeah, I think
It's
that's
a much larger.
I think that's a different. I think
That's a different scope.
Yeah.
I mean, what happens if you like don't get along with your neighbor and they don't let you on the property to
I had no
reshingle
idea.
your?
I had no
You left them on. Yeah,
I've
I
been
mean, they
there,
can't
done that.
prohibit you.
And that probably requires insurance policies
Sure.
and a lot of other.
Builder's risk policy.
certain times where you can access the property.
Well, I think you can handle it both ways, so it's really up to you, Ed.
To me?
No, to them. I mean, you can get a building permit for 80% of this work now, if you really want to get that letter. So that's,
I think the letter, it should be in the file.
okay. So I'm gonna make a motion to continue then based on that.
Works for me.
If that's the majority, does that how everybody feels?
Just to be clear, since I haven't heard about this other application that's been requiring this. So it would just be a simple letter from the neighbors saying, to the extent necessary, if you need to enter our property, you have permission to do so to make the renovations in conjunction with this project.
Yes, perfect.
And that
Something
they'll
to that.
make reparations if there's any damage to.
If there are any things.
to their property.
Yep. Okay,
Okay.
so I make that motion.
All right, Lisa made a motion. Who wants to second that?
I will.
Michael seconds it.
Oh, Michael.
Any further discussion? No. All those in favor say aye.
Aye.
All right.
Thank you.
That was continuing to October 11th.
Yes, that's right. Is this the Nobby shop?
Yeah.
I was like,
36.
who is Michael Scott? I couldn't figure it out
From
now.
the
Kids.
office.
No, I wrote, you start paying him rent. So I remember the name.
I think it's his kids, maybe.
I used
Oh,
to.
I thought it was a joke, like from that show, The Office.
Oh, really? No, I think it was called that before The Office.
I don't know.
All right,
I don't know.
3618.
That's interesting.
I was like, who would call their thing Michael Scott?
Yeah, it's right there. All right, 3618 Michael Scott Realty Corporation, 17 Main Street for the applicant.
Is anyone here?
Yeah.
Oh,
The
Linda.
esteemed Ms. Williams.
We're in tandem.
Ms. Williams.
Liz.
I think it's pretty self-explanatory if you've looked at it. We have a bunch of old permits for the Nobby Shop building that no longer are relevant, except for one part of the very first one. Because they're now in the CDT, which means no parking requirements, no loading requirements, the ground cover has changed, the setbacks have changed, the uses are allowed as a matter of right. The first permit, I was involved with all of these permits. One of them has where, if you remember the old Opera House, the Nobby Shop actually owned the patio that was in between, and that was the one where they came in and they expanded the building, the two-story building. Sarah Alger's office was in there. You came into it from North Water Street. So that's the only part of one decision that needs to remain intact because they did need the special permit to expand the building. But everything else is off.
You mean where?
Was that the Opera House space?
Yeah, there was one lot where those little stores are, but in between the two buildings was the open patio. That belonged actually to the Nobby Shop. So they
That's where my
expanded the
office used
buildings.
to be.
Yeah, so
Yeah.
they expanded the building over the top of
So
the
it's
patio.
that real estate. They built the apartment.
So the only thing left in the permits of anything would be that one permit. And that's half that one permit.
Michael,
Which
this is
permit?
sort of- Go ahead.
No, go ahead. No, which permit are we looking at? That's the one that we need to.
It is,
8786.
8786.
yeah, the very first one.
Okay.
Pages 221.
Yep, I got it.
So we'd ask that you file something at the so we can file it at the registry saying that they're all vacated and that part is still in existence.
Were you just trying to
Well, I
say
was-
this along the lines of what Michael?
Yeah, along the lines of what Michael said, why can't you just do this why do you even need any sort of relief?
I was going to answer that question, but I'm up back there, so I can't run down and answer it with the 25 years I was with the
Well, it
ZBA.
doesn't matter because now John Brescher's gonna get rid of it.
Well, he can't. The reason why he can't, and we were over this when I was there because we were changing zoning in places that the permits became moot, is because you need to file something at the registry. You need to have something actually vacating them at the registry. Otherwise, anybody doing a title search is going to think that these permits are still in existence. And without something in writing to vacate them, they have no idea if they're still held to them or not.
So that could be done at the administrative level.
Theoretically.
As well, if I may, there's also the fact that abutters may be relying upon these decisions.
My office was not
So
legal.
that's why you rescind them, because they will get, these are mailed out to the abutters, so they are made aware that the relief is no longer necessary, why it's no longer necessary, and that they
Because,
no longer rely upon it.
yeah.
I agree, I'd like the cleanup
Yeah.
aspect of it, but when you change these laws, you have to go back.
Yeah, that doesn't make any sense
If
to
there's
me.
relief, I think it's a good idea just to clean it up.
Yeah.
Technically, you probably could go along without doing it, but most people do prefer to clean it up, and as a former title examiner, it's better to do it that way.
I mean, can't we say that can't we determine that no relief is necessary?
No, because you already granted it. So you have to vacate them.
I'm asking Ellen.
I'm gonna ask.
so.
Well, I've been over this a million times.
Before, the rescissions that we have done, you probably recall, are based upon change in bylaw that render the relief moot or obsolete. So you have to narrate that into the decision and explain why it's no longer necessary. So you're like she calls it vacating, it's a rescission.
Yeah, either way.
Can I ask one question? Just about, because I'm realizing that we were not legally actually able to have office space where I rented, because it says commercial use to one retail clothing establishment with retail space accessible to the public. In addition to the
Which number?
Number 4. In addition to the respective primary, secondary apartments, which is my office was one of those apartments, each for year-round use only, some space not to exceed 1,260 square feet of the second floor may be used for office purposes ancillary to the retail establishment, otherwise for the apartment use. So is that something that has to be
Vacated. It's
Is it
allowed as a matter
allowed
of
to
right.
Maintain now.
Is it allowed to be
If the relief is not
new office space
necessary,
with CDT?
yes, it'd be office space,
I'm asking
apartment space, any of
Eleanor.
that stuff.
I mean, it can be
So
anything.
by rescinding them, what you're doing is you're cleaning the slate completely. So whoever this building is, I believe.
Sold to.
It's, so whoever takes over, there's another one coming down the pipeline I haven't been aware of. Whoever takes over will have to put in place compliant uses. If not, they'll go to the planning board.
Compliant use is based on this.
Based on the use chart, based on
Because it's
139.7.
CDT.
Right.
Yeah.
The new use chart.
The new use chart.
Yeah.
So
Yeah.
this number 4 goes away.
Yep.
However,
Well, no,
if they didn't do anything, it doesn't mean that.
Technically, these decisions are restricting the uses to what is stated in the record, technically.
Well, arguably, if you felt that condition should still remain, you could keep that condition
Yeah, because
about
we
the
just-
ancillary use to the retail space and not.
That doesn't exist. The apartment is now back. The third floor is now back because they never exercised the conversion to another commercial use up there.
So the second floor is now an apartment.
It's an apartment, and he's got his little office in the back, but it's not going to be going with the apartment. It's got 3 condos in it. All of these uses are allowed as a matter of right. No one else on Main Street has any condition related to any of what we got on these decisions. These are all allowed as a matter of right, and they don't have those conditions. We don't know what's going to happen to the office because it's on the same floor as the apartment. So it could very well go with that condo as opposed to the retail on the first floor. There's 3 condos in the building.
It's going to be 3. Your client would like to have 3 housing units and 1 retail store.
Just
2 housing.
2. The third floor, and I believe the second floor for sure. The second and third
Second
floor.
floor will be an apartment.
Yeah. So we don't know what they're going to do with these person's going to do with these condos. We just know we have 1 retail and 2 apartments.
Didn't we just have the one on Easy Street that was in the CDT, and that one had apartments?
Oh, a lot of them
Yeah,
have
I was
apartments.
just reading that the decision had restricted
No, so why can't we keep those
to commercial
restrictions?
space. Oh, you mean to only? Well, they're only going to have 1 commercial entity in here.
So they say. I mean,
But
if there was a
multiple
reason that the
retail is
board-
allowed as a matter of right. Again, it's allowed as a matter of right.
With the use chart.
Right.
Right.
Would they, Eleanor, would that building today meet all other CDT
According to
requirements?
what she's indicating are the uses, yes.
One
I mean, in
one
terms
thing
of
doesn't.
the setback.
Please.
or
Yeah.
something,
I mean, in terms of the size of the building, I mean, they could build that building as a matter of right today, as is.
Oh, it's an attached building, I don't know how they do.
No, they have to do the whole block. The whole
Yeah.
block is in,
I actually do not know the answer to that question because it's don't know what the lot size.
We don't
exact
actually
lot
have a
size is.
survey.
it's
one
part of the block.
Yeah.
It's not a standalone structure.
Well, it actually does not share a wall with,
It doesn't?
No.
Oh, you're
No.
right, it doesn't.
there's like a
It's not
little,
part of the rock.
The only thing it doesn't meet is if you take the front yard from North Water Street, it meets it. If you take it from Main Street, which is traditionally 17 Main, is the front of the building. The downtown allows a 0 side and a 0 front and a 5-foot rear. But because we allowed them to expand the building by special permit back in, 30 years ago, then the rear does now not meet. If they were to build it again, one of them would have to meet the 5-foot setback. That's about it. But everything else is allowed or a matter of right. And if we're going to vacate them, they need to vacate them in their entirety. You can't hold them to conditions when the relief is no longer necessary.
Well, some relief would be necessary because it violates the rear line setback you just said.
Not any of the uses and the conditions. The building itself has that special permit from 1980. 86, that allowed it to expand as a pre-existing non-conforming structure.
where was the second means of egress in that office as a residential unit?
You know where the print room was?
Oh, yeah, behind the
Oh,
old
yeah.
bathroom.
Yeah,
Center of the building has 2 stairways.
Got it.
I couldn't find it the other day, but I did.
That answers Michael's question, because if it's by right, there's no reason, and these restrictions don't apply. I mean, I'm all for cleaning up the roads, so, but
We don't have to beat the horse.
Yeah.
Let's move on. I mean, are we all okay with this?
It seems like it's just cleaning up.
Yeah, so we're going, to be clear, we would make a vote on each one of these decisions, rescinding or not?
Yeah, I'll do one decision and encompass all of them, and they'll be marginally noted on each recorded document.
With a partial rescission of
Well, the
number 4,
1980s.
right?
Yeah, the first one.
So I'll tease it out, and then you'll sign it, you'll see how it'll be elucidated in the decision.
All right, so somebody can make a motion to make a partial rescission of 87 -86. If somebody would. Keeping the part that had to do with the expansion of the structure, since that relief was necessary.
Sure, that's the only part we're keeping.
Yeah. Because the other conditions are
Are no longer, yeah. I'll make that.
Not each condition, but I think that a blanket statement to that effect. And
I'll second your,
okay. Any further discussion on that one?
No.
No. So all those in favor say aye.
Who's voting on this?
So the 5 regular members, aye. Is that unanimous? Yeah. Okay, 109-87 would be
In its entirety.
a full rescission.
I'll make that
And
motion.
that's because there's no relief now required for items placed within the side yard setbacks.
I'll make that motion, yeah.
Okay, so any further discussion?
No.
All those in favor say aye. Aye. 02490, seeking a rescission in its entirety, no relief as parking is no longer required for retail uses in the CBT. And retail and office uses are allowed as a matter of right without requiring parking and loading. In addition, the applicant is seeking to vacate the condition therein that the retail be operated on a year-round basis. Do we care about that?
Sort of. I mean, I think it's nice to have it open year-round.
I do too.
What's going in there?
We have no idea. It's a,
I think we keep it. I mean, there was a reason that the board put it in.
Okay.
it doesn't really exist, the reason doesn't exist anymore today, and it was 30 years ago, and it's kind of unfair to force him to do that when no one else has the same. Not one thing downtown has that condition, not one.
They-
And we don't know who's taking the building. And Sam is tired, he's getting out, and he's gotta go. I mean, if you go in there, it's almost empty now, but that would be unfair to keep something that no one else on Main Street is forced to do. The selectmen are gonna have to deal with that issue as a broader issue. And we brought that up to the selectmen many times.
I don't remember anything to do with this application, but I was a tenant next door when this building was built. And it was a different world back then, and I have no idea why this condition was placed in the decision, but I rarely agree with Linda, but this is one of the times I agree with her.
So
As
if you
we've gotten
went
older, Michael, it's been better.
in- 90, this was 90.
We got that on tape.
Yeah,
This
you got that.
was a good 28 years ago.
Well,
It was longer than that.
Well, this decision was
Yeah.
90.
Yeah, 90, okay.
I guess it's true. I mean, most of the two people that are your tenants aren't open
Times they
year-round.
have changed.
You were taking
So-
the most
It's
popular
unfortunate.
It is
restaurant
unfortunate.
I mean, it makes
On the
downtown
islands.
bad.
Yeah, but you're gonna make your tenants stay open year-round if you're gonna make
Alfresco
them, so.
sitting.
Nobody's
Yeah.
buying art.
Along with a bunch of other stuff.
5K.
It's hard enough in the summer,
You were in
right?
diapers. He was in diapers.
So I'm okay rescinding this completely.
Mid-season salad.
Well, again, if you went in for this building today to get a new, just to build it,
They don't ask
regardless
you.
of the rear line setback, you would not be restricted.
That's correct.
That's
Right.
correct. So I'm gonna make the motion to rescind that.
Okay, so again, that would be in its entirety and vacating. Well, if we rescind the whole thing,
Yeah,
it's not in addition. It would
Right.
automatically go away.
exactly. That's
Yeah.
what I make the motion to rescind the whole thing in its entirety.
All right, any further discussion?
No.
No, all those in favor say aye.
Aye.
4992, applicant is seeking rescission of the decision in its entirety. No parking relief is necessary as parking is no longer required for retail, office, gallery uses in the CDT. Uses allowed as a matter of right are no longer limited by parking and loading zone requirements. In addition, applicant is seeking to vacate the conditions contained therein restricting number and nature of commercial units in the structure, as well as the requirements that one unit be limited to year-round use. Now,
Now that one's a little bit.
again,
I like the idea of the year-round housing. But you're saying that
it's
They
a
would-
different world. Are you still on the different world page?
Well, I mean,
That was
should have
92.
I should have said that I frequently don't agree with Linda, not never. So I apologize for that indelicacy. But I would say yes, this falls into the same category.
Different world.
And it is an income generating apartment for Sam, once his brother had to move out of there.
yeah, I mean but he wants to do it as a seasonal rental unit.
Yeah, because he's not in there. And almost all of them in town now, the higher end apartments are all seasonal rentals.
I'm not sure I'd call that higher end, but
And it used to be attached to the first floor retail, but it's not anymore. It's a separate condo.
I know it's just too bad because we need year-round housing.
Well, it'd be interesting. What were they asking for in this particular?
To go to
just-
gallery.
Just the parking?
It was a gallery
Yeah.
at one point, right?
Yeah.
Yeah.
That we just went to the state and they sided with us. But no parking relief was, the only thing was parking. That's it.
So the condition of it being a year-round residential apartment was,
He won't have control of that apartment anymore.
who won't?
Sam.
No, but if this weren't rescinded, it would be on there. So what if he has control? The next guy would have to.
Well, we're asking for the entire rescission of it because the reason for the decision was because of parking, and parking's no longer required.
But there was, hold on, I just want to read this.
I gotta read it a little closer.
The actual apartment had nothing to do with this decision. It was just carrying over previous conditions. Every time you do a new one, something would get carried over. And you've already removed that condition in earlier rescission. I'd hate to start cherry picking him now.
I love the wording. Did you write this?
I don't think I wrote this one.
The application is ripe for relief by special permit.
No, I wouldn't use that.
Very flowery.
That sounds like an attorney.
That would probably be an Arthur Reed at the time. You got some Bill Sherman in here, Andrew Letty in here, Arthur Reed in here, Rogues Gallery.
I don't even see that condition. I don't even see that.
And anything future with this building would go to the planning board, not the ZBA. And they have not required year-round occupancy of these in-town apartments. Out-of-town employee housing, yes, but not in town.
That's why we're building all those big buildings.
Yeah, it would be nice if there was a,
Had some year-round housing in town would be nice.
they being, I don't know who they are, but yeah. I don't even see that. I don't even see that condition.
Move on.
Anyway, I don't really, I mean, again, if you came in today, you wouldn't have to comply with.
I know, it's just a
It's
shame
just unfortunate, so
that
let's move on, so.
The planning board doesn't require stuff like this.
All right, so does somebody want to make a motion to rescind that?
I'll let somebody else do it.
All right. Somebody else, please do it. I'm begging.
I'll make the motion.
Thank you, Karen. Michael seconds it. Any further discussion? All those in favor say aye.
Aye.
All right, 9707, seeking rescission entirety.
They never exercised it.
It's no longer necessary because it includes blah, blah, blah. It was never exercised, so therefore, why do we have to, if it's never exercised, why do we even have to bother?
It's on record. And we had to go to Boston last week in order to validate that it was never exercised. We had to go appeal a decision by the building department, and the building department was overturned, that it didn't happen. The apartment was still there.
Eleanor, I'm asking you this time, if a decision is never exercised,
It was
because the
recorded
work
but
was
never
not
permitted.
done.
Okay, okay.
But we have
If it
to,
had not been recorded, it would not be an issue, but it's been
Right.
recorded with registry of deeds. So this is really a matter of cleaning up the title.
Okay, so what was this one all about?
oh, they wanted to convert the apartment to a full-fledged gallery, which they never did. But there was an argument in the building department about whether they did or they didn't. That's why we went to the state, and the state upheld us and overturned the building department. And now they have a CO on the apartment.
They put a kitchen in?
It's always been there, they never took it out.
Where was the kitchen in our apartment?
In the middle.
In the middle, yeah.
All right, all
Were
I
we
can
at our
say
conference
about this
table?
is, I don't think we're probably reading all this quite as closely as we should, no?
Yeah.
So.
I don't remember any appliances being in there.
I think we need to rely on Eleanor to,
Yeah.
or I'd like to
Right.
rely on Eleanor to confirm that all we're doing is rescinding things that are no longer necessary.
Right. You're leaving the one piece of relief that is still required is in that initial decision to do with.
And all these other
setback.
rescissions, you would not need any of this relief today.
No, these uses are allowed by right in the
Alright.
CDD, and there's no parking or loading zone requirement.
And Leslie and I spent 2 hours going over every decision.
That somebody did.
The ZBA decision, the building inspector was hanging his hat on that when we were trying to convert from the office space to an
Convert.
apartment, even though the ZBA decision was only good for 2 years, it was never acted upon, he still was holding that as gospel and that would not grant us.
Yeah.
Now we had
Yeah, and I'd go all the way to Boston.
And then it was never acted on, it was never brought forward.
And
Well, it
then,
was acted on,
Trim up on
in,
front.
in reality, it was an office, wasn't it?
It was an
was.
office.
but that was permitted by an earlier decision. We're talking about the apartment itself was never activated as a gallery
How come I went-
officially.
This says,
I went to an opening at
Yes.
that gallery.
Reggie would have
On the
his
second
stuff
floor.
there, but they said that a lot of it hinged on whether we had to sprinkle the building or not sprinkle the building. That's where the argument started. And
Well,
we
this
got up to the
says-
state, and the state said, "Why are you here?" The apartment never left. What he was running basically was an art salon.
There were no appliances in that room when
Yeah,
we
they
had
were.
our office there.
I was up there
Not
during
when
one
we
of
were
these.
there.
They were all stubbed off. There
Yeah,
was no-
well, I'm
so-
saying there was no kitchen there when we were in there. I haven't lost my mind. I know there was no kitchen. in
Be
there.
that as it may, they sided with us
They
and
were
said it
behind-
never
they
took
were
place,
subbed off.
and here you
They had
go.
taken the kitchen out. It was not an apartment when we rented that place.
but this says the new space would be used exclusively for storage for the retail occupants of the building
No,
upon the
legally, like the way
locus.
Which one's that?
This is
Hold on,
page
don't let
two-
me talk. I
This
can't-
is page
I'm too
239.
What, 239?
Isn't that what we're talking about? 236 to 240, 9707.
Yes.
Yeah. What does it say?
And you guys were saying it was going from an apartment to.
A
You said
gallery.
entirely for storage and support for
Yeah, and this
existing
doesn't
retail
say it was
store.
going to a gallery. It says it was the new space would be used exclusively for storage for the retail occupants of the building upon the locus, and indoor trash receptacles and mechanical systems for the occupants of the building.
I don't know about these pages here. All I know is that that's why we were in Boston. It's because it was supposed to be a gallery and it wasn't.
That's not what it says.
And it's always been an apartment. The apartment was there. They agreed that the apartment was there. The fire alarms are there. The accesses are there. And they asked why we were there. You can, of course, have an apartment back without having to sprinkle the building.
That's not what this decision.
That's what we went to Boston on, based on that decision
As
from.
Susan just told you, that's not what this is about.
This one says
This is about an addition.
This says the
It is
applicant
this one.
proposes to construct a two-story addition to the existing commercial building upon the locus to be used for additional storage.
That's the first decision. That's not the last one.
What's the
It's
date on it?
9707, so it's the last.
Yeah, you're reading the wrong decision.
I am?
The decision we're looking at is 09707.
That's right.
And 04992 was reference to gallery again, and you've just waived that
Where do you
one.
see
We're
the
just asking this to go
decision
away
writing?
because the permit was never exercised.
What is it?
But it had nothing to do with gallery.
This is January, it's
Are
dated
these in the
January
wrong order?
14th, 2008,
Oh,
9707, Michael Scott Realty Corp.
So that is the,
Book 1126, page 334.
Where are the
so
site
that
plans
is in the back
associated with
section of the
this?
building?
I don't know, but this is the one you're saying that. this
That's
is-
not the apartment where we're
That's part of
talking
that's part
about.
of
That's the back part.
Back part of the commercial space.
The
Right,
part we're
that's what
talking
I'm-
about is gallery, which was in this decision, which went to the state because of the sprinkler system. All I know is that these are all
There's
dead,
no word
not
about
exercised.
gallery in
Linda,
here,
what
so I
I'm
don't know
saying
what the
to
hell
you
you're
is
talking
you're
about.
asking us to do a full rescission of a decision called 9707. I'm looking at 9707. You're telling me it was changing an apartment to something else. This
don't have it in front of me.
9707 is about
you have it?
construction of a two-story addition to the existing commercial building to be used for additional storage, filling in an area of the building along Cole Alley now
Right.
containing
It was
outdoor
never
stairs and
done.
trash.
They never made the addition.
Yeah, because I
But
rented
that's not what you're
this
talking about.
building.
You're talking about it's
A
still an
gallery
apartment
space.
changing to a gallery.
That's the one before
That's
that.
not even what this is
Yes,
about.
she's talking
I
about
think that's
Arthur's
the one
decision.
before
The
that.
two-story addition in Cole Alley never took place. That's why this one is out. So we're talking about, the one that went to Boston was 04992, the one you already waived. This last one was never done. They never did the two-story addition. They never changed Cole Alley at all. So yes, the one before this that you just waived on the gallery is the one that went to Boston. You got a little confused.
I don't even know why you keep bringing up this thing about Boston. We're trying to talk about.
I know
Right.
you're
We're
really,
clarifying
but
that.
you're making it really confusing.
09707, we've got the numbers wrong here, I was looking at them. 09707 was the addition in Cole Alley to fill in the space that never took place. That's why it needs to be officially rescinded. 04992, the one you waived just before this one, was the one we had to appeal to Boston. That's the gallery.
Okay, I have no
Right
problem rescinding 9707. It
Yeah.
never happened. The addition never happened. according to the applicant.
Yeah, I mean, that's right.
You know, this is,
Okay,
why
you guys don't have to be
aren't the
argumentative.
site plans and whatnot attached to these decisions?
This is the one on the side. You never
The permission will consist of all this.
And floor plans, I mean, we really should have floor plans as part of the exhibit.
Remainder of the building will continue to be.
So you want,
Boston.
yeah, we're in Boston, you just go to local,
Yeah.
pub and is there a
The building.
specific-
Yeah.
BBRS, Appeals Board.
Really?
Yeah.
There's a lot going up there,
Fire marshal, an architect, and a state inspector.
the inspector. Engineers
All to
go,
clean this title up?
yeah. And to get them so that you didn't have to
Why
put
did
the
you have to go to
sprinklers in.
Boston first? Why didn't you just come to us to rescind it?
You can't do anything with the building code.
Oh, because they're building code.
It was a building
violation.
code thing, that he relied on the ZBA permit for a building code issue.
Basically saying the ZBA supersedes the building permit.
Yeah. So that didn't last long.
Yeah, that doesn't.
Well, we didn't want to do that.
Hello.
So can we clean up 097, 07 that never got done?
Sounds like it.
Yeah. So, I'm okay with that. You did? Okay. Mike, do you want to second that? Okay, no, motion's been made, second. Any further discussion?
No.
No. All those in favor say aye.
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 All right.
Thank you.
Goodbye.
I hate to see the Nobby shop go.
See what?
The Nobby shop go? I never went in there.
Put bowling alley.
It's Skechers.
Did you get those on sale there?
Okay, did you?
Make a motion to adjourn? I'll second Karen's motion.
All those in favor say aye.
Aye.
Next month meeting is October 11th. Do you all anticipate being
I
here?
will not.
Yes.
You will not be here on October 11th?
No.
He'll be on his big walkabout,
His drive about.
his drive about.
When? 40B is October
That's
3rd.
October 3rd.
Anybody else? Karen just.
Because, well,
I tried
you
to be
knew